Good morning, good morning, good morning, amazing law nerds. It's so good to see you. And for the replay crew, as always, everything will be timestamped down below. It is Wednesday, it's August 20th. The Donna Adelson trial is underway in jury selection. And since they are doing jury selection, we're going to talk about some other stuff. Why? Because we can. There is stuff going on in Idaho that I thought would be helpful to talk about because, well, I saw a lot of questions about it. I saw you guys asking about it in the comment section on the stream and on the podcast episode. And thank you to everybody who rolled over and checked out the podcast episode on the Emily Show channel. I appreciate it. So I saw all of the questions there, and I figured today we would just talk about it because, well, we need to talk about it. So today, we are going to be talking about two of the victim families suing Bryan Kohberger. We are going to be talking about that lawsuit, what the judge just ruled in that lawsuit, when it's going to hearing, what's happening, why it's happening, what's going on with these public releases of documents and the rest of it. And then we are going to be talking about the case that all of you know and love, the TikTok psychic. Yeah, we're going to talk about the TikTok psychic case. We got to talk about the TikTok. I know. We got to talk about the TikTok psychic case because, well, it's been set for trial. So we're going to talk about that. If you're like, Emily, I have no idea what that case is, it's okay. It's okay. I'm going to give you a road so far. For those of you that do know what that case is and are ready for an update, I got you. I got you. So we're going to talk about it. That's what we need to do. Laura immediately asked the question that all the law nerds are thinking, will it be streamed? No, it's in federal court. It's in federal court. It won't be streamed. But we're going to talk about it. We're going to go through the lawsuit in Idaho. We're going to look at that case docket. We'll go there first. And then we will talk about the defamation case of it all. So happy Wednesday, everybody. And don't worry, if you're waiting for the Adelson trial, same today as yesterday. They are just a quick update before we roll the intro. Quick update on what's going on with Adelson. They are going in groups of 50 to get a full veneer. Some judges call it a venire, which is probably properly Latin, but I just know. So they're going through groups of 50 to get a veneer. So as they are going through those groups of 50, they are excusing jurors essentially for cause. Jurors who have already made up their minds about the case due to media, jurors who can't sit for 3 weeks in trial due to life or circumstance or whatever won't work for them to sit for 3 weeks. They're going through all those things in individual voir dire. So you saw the judge asking the broad questions of the entire panel, like raise your hand if you are a sole caregiver for a child under 6 and need to be excused, that kind of stuff. So we have the court going through those groups morning and afternoon and really yeeting everyone who can't sit, knows about the case, what have you. He's hoping to get from 300 jurors brought in, if need be, down to about 100, and then from that 100, picking a jury of 12 plus 3 alternates. The court anticipates picking 12 plus 3 alternates Thursday. If that goes really swiftly, they could have opening statements as early as Thursday afternoon. If it doesn't, it will probably be Friday. So are we streaming Thursday? We'll see. It's just going to depend. I'm going to wait and see where we're at with the jury selection, and I'll let you know in the app at the end of today where they're at and how that looks. If they need to bring in more to qualify Thursday, then they won't have a jury Thursday, or at least not until the end of the day. So that's what they're doing. They're going through groups of 50, weeding out everyone who can't serve, and then bringing back those that might be able to serve to do the attorney voir dire process, and then literally seat and yeet of who might be the jury. That process has actually gone pretty quickly because they're doing that big group voir dire and removing everyone for cause or plane tickets or childcare or what have you. So Thursday should go pretty quick. we'll see if they had 63 or 64 yesterday. So with 63 or 64 yesterday, if they get another like 60 today, they're going to start seating jurors early Thursday morning, and we could get to openings entirely on Thursday. So again, Law and Order app, I'll keep you posted. With all of that, I'm going to roll the intro. Fingers crossed. And then we're going to talk about Idaho. So we're going to roll the intro. We'll fly to Idaho in a minute. At some point, we'll choose to fly to Idaho. I don't know. We'll do it. B Rocks in the chat said, motion to call jury selection seat and yeet henceforth. I think we should. It was a chat. Look, it is a chat amalgamation of how we've been talking about it, and I'm ready to do it. Sam and Colby, one fan, how do you get updates on the jury? Well, I'll tell you in the app, but I've been watching in court and hearing what the judges said. And then there's a few reporters in court from the Tallahassee Democrat, which is where this is also streaming. So yes, B-Rock's seat and yeet was kind of an amalgamation of how I had referred to jury selection in the past. And then when I started talking about yeeting, the chat said, no, yeah, we'll seat or yeet. And then it all just kind of came together. So yeah. So seat or yeet. So I think they might have it tomorrow, but we'll see. So let's roll. Do I have coffee, Emily? It is not kicked in. I do not have enough coffee. It's been very busy. We've had lots to do. We've had lots to do. Miss C in the chat said, I'm surprised to learn this week how sketchy Robolx is. There are really some things going on. For those of you that saw the podcast this week, and so many of you had positive feedback on the podcast. For those of you that are like, what are you talking about? We live stream. The Emily Show channel on YouTube is where the podcast lives. And we talked about Robolx this week, among other things. And a lot of you were like, can we cover this more? Yes. And I was really appreciative of the feedback in the comments that a lot of you want to know about what's going on with Robolx, but don't want like all the details. And so especially when we're doing topics covering kids, that is the balance I always try to strike on letting you know what's happening without leaning into every single potential detail that you need to know, because you can get an idea for how bad it is and then decide if you want to go seek out more information. So that's always my goal. So let's roll the intro and then we will go to Idaho. So let's go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Emily, are you dancing in the background every time the intro rolls? Yeah, I am, and reading the chat. So for those of you who have had conversations with your kids or teens or young adults about Robolx, aren't they really an interesting font of information? They are just incredibly forthcoming with that. And yeah, a lot of the kids on the platform know exactly what's happening on Robolx, and they really do talk to their friends about staying away from it and like the online stranger danger. It's nice to hear about the conversations they have with their friends. And as most of you can turn off voice chat and chat, it helps. But anything that has a chat platform has the potential for these problems. That's why YouTube turned off all the comments section on video made for kids. It's one of the things, well, your kids can come across videos. I find it very easy to go through my kids' YouTube history and see what videos they've been watching, even though stuff will slip through. But there's no DMing function on YouTube, and the chat functions on most kids' videos are turned off. So there's not as easy of a way to connect with kids, which is what we are seeing be a problem in Robolx. But anything that has a messaging component can have that issue. And it's different than like, I don't know, you look at like a Call of Duty, like an OG Call of Duty lobby, and you're looking at all of the awful words, insults, and speech you would never want your kids to hear. But it's less of people giving kids money and then being like, we should meet in person. Where do you live? Where do you go to school? And the rest of it. That's where shit goes really sideways on Roblox and some of the other chat platforms. So we will continue to talk about it, not here, but we will talk about it on the podcast in weeks to come. Barry SD said they can give them money. Yeah, Robux. You can give people Robux and put Robux on people's accounts. Yes, Robux is in-game money, but any kid who is deeply invested in Roblox, they rather have Robux than actual cash. So it's an entire thing, but we'll keep talking about it. So all of you, I appreciate it. I think you guys I love that you guys give the feedback of like, thank you for covering this. I love it. Jessica said the amount of money I've spent on Robux, it's true. And Jeanette said my niece and nephews were obsessed with old school Roller Coaster Tycoon. I am so old that I remember when you could buy Roller Coaster Tycoon as like a disc game and just put it in your computer. I miss that. I miss just being able to buy a game and just put it in your whatever you're playing it on. So Laura asked, what about Minecraft? Minecraft doesn't have as many messaging features, and Minecraft is much easier to cordon off into a space. Minecraft, you can set up your own server pretty easily and have like a literally walled garden of Minecraft that only people who have access to to that server have access to. So Roblox is way easier to control. So that's what I think. But we're going to keep talking about it. It seems like it's been helpful, and I appreciate it. I miss all my old computer discs. I know. Me in law school trying not to get caught playing The Sims on my computer. Do you know how mad I was in some of the classes that sat us in alphabetical order being a baker? And I had gotten married right before I started law school, so Baker was like a new last name, and I was like, shit, I'm now at like the front of the alphabet. I hate this. I want to sit in the back. I want to have like one window for notes, an AIM chat window, and The Sims playing on like a giant Gateway laptop that weighed about 175 pounds. So wild. But it was also my iPod because I didn't have an iPod, but I had iTunes on my computer. So I hauled that shit everywhere so I could constantly have music plugged into my brain. Oh, the old days. Emily, did you ever have to wipe your computer because of LimeWire? Who, me? I would never. I would never. Yeah, it totally happened. All right, so let's go to, should we fly to Idaho? I feel like we're stuck in Florida. Do we need to are we ready for some miles? Do we want some miles? We want some miles? I think we do. Everybody's like, yes, I want my frequent flyer miles. We need to fly. Come fly with me. We need to fly. I get it. Yay. Y'all were like, get me my miles. We had to get from Tallahassee to Moscow, Idaho, because a lot of you had been asking about what is going on with the lawsuit over pictures in the Kohberger case. Let's do a little bit of a background on this, and then we're going to pull up some of the news reporting on it. My cat has been leaving like gifs of glitter on my microphone, and now they are too close to my face. Which, with the new software, you can probably see because it's so much clearer. So that's a whole situation. But one of the problems that we are having in Idaho is that there have been so many public record requests, and different law enforcement agencies said, look, we're not going to be able to accommodate all the public record requests. We're just going to put them up on a website and you can just download them all. And so with that, there was a release of over 200 crime scene photos. Some of you may have seen them online. That is not something I would ever share, because here's how that would go if this case had gone to trial. If this case had gone to trial, it is most likely that the crime scene photos, autopsy photos, and other type of photos, except for just a very few, would have been sealed like we saw in the Murdaugh case. In the Murdaugh case, remember, Emily, are we taking a Are we taking a side quest so soon? Immediate side quest. Immediate side quest. Remember in the Murdaugh case? Remember last week in the Murdaugh case, Courthouse Becky is now being criminally prosecuted for perjury, for misuse of official duty, and other things. But in the Courthouse Becky case, one of the things was that the crime scene photos were under seal and she allowed people access to those photos. There is more there. But that was the clerk of court. Those photos came in at trial as evidence and then were sealed. They were not supposed to be shown to anyone, released to anyone, leaked to anyone. None of it. But it happened. But in a trial process, the evidence would have gone through the official process of being marked as evidence and introduced as evidence and then sealed outside of the jury view so no one else would have access to it. Because this did not go to trial, there are a ton of public records requests, and it seems that the agencies aren't necessarily weeding out those requests, and they're like, we will just make it accessible to everyone. But that included crime scene photos. And yes, some of the crime scene photos are blurred, but there are still crime scene photos that have the victims in them, though blurred. And I have not gone through and looked at all 200 photos. Why? Because I've seen the police reports and I can tell you exactly what that's going to be like. I've dealt with a lot of crimes in my life. I don't need to see it. Don't need to see it. I know well enough what photos are going to contain. And the difficulty is that because there wasn't a trial, photos didn't go through an official process to be sealed. So as all of the public records requests are coming in and all the different law enforcement agencies are just putting them up on different websites that are theirs so people can access them, they have tried to balance, and I can understand how this happened. They have tried to balance the right to privacy with some of the things that were blurred and the public's right to request information through a PRA request, through the media's First Amendment right, and others. But in all of that process, there was no judge looking at what was getting released and going, this can go, this is sealed, this is here, this is not. And in that, we end up with this lawsuit against the city of Moscow over the photos that have been released. And we have a docket. We can go through Bryan Enton's interview. A lot of you have brought it up because we don't have the full body of the lawsuit because it is not on the docket. And the court has not sent it to me, though I have requested it. We will see. So we will go through the reporting about it. We will go through the docket. We will go through the press release from the city because the court has now issued a temporary restraining order, which is essentially a non-dissemination order saying nothing is getting released until this goes through court. I understand all of the different interests at play here because agencies are trying to adhere to the public records requests, which are flooding them in a way that they have not seen before. There are things that the public wants to know about this case, and there is substantial interest in this case. The media can't really access or act as a gatekeeper in this because not everything has to filter through legacy media that has a team of lawyers like ruining everybody's day going, no, you can't, no, you can't, no, you can't, because they are just available to everyone. And there's a part of me that loves that the media can't just gatekeep and be like, well, obtained by us and no one else. So we get to tell you what it says and we get to tell you what we think. And no one else really can check us because no one has access to the information. However, then you end up with victims' families being like, how the fuck are any of these photos on the internet? And I have so much empathy for them because you don't ever want to open up your, let's be honest, your Facebook or your Instagram to come across pictures that you might never want to see. And it's really hard to opt out of the internet. So I get how we got here, but it's unfortunate. And this is not the first time we've seen this. We covered it briefly when we were going through one of the lawsuits regarding a celebrity death in Florida, and the family had sued to keep the autopsy and autopsy photos from being released because the media was already asking the coroner's office for the autopsy and autopsy photos, and the family won that lawsuit with the right to privacy. There was no litigation in that. It was an accidental death. There was nothing surrounding it that needed to be out. But we have seen this happen before where people have gotten access to autopsy reports plus photos and put those online when most media outlets wouldn't. We have seen other cases. Some of you in the chat are mentioning the Kobe Bryant case. We have seen that happening in the Kobe Bryant case with, well, there was a massive lawsuit that the city of LA or the county of LA is still paying for because first responders had taken photos on their personal cell phones and were showing people photos. I understand the public's interest in this case and wanting to know more about this case. I just think because I worked so long in criminal prosecution, I don't understand wanting to see the photos. Like I don't, because I know that you can't unsee it, but I don't know if everybody knows that, but you can't unsee it. And it's not the law nerds. Y'all can't explain to me because it's not y'all. But having a judge go through the photos and release, if there are photos of the home where no victims are in the photos, I can understand. But even if you have to blur out the victims, let's just not. That's where I am. And I'm sure some of the media would be like, we have a First Amendment right to everything. If it went to trial, they would get sealed. So that's where my perspective is. If it went to trial, would it get sealed? Yes, then it needs to get sealed now. That's my perspective on it. That's how I see it. If they are photos of the house that go along with reports or photos of footsteps in the snow that go along with the reports, okay. But if the judge would have sealed it, then I think it should be sealed. And I think that's probably what's going to happen. This goes to hearing tomorrow on the temporary restraining order, and then a judge will get to go through all of the photos and decide. I just hope that we don't end up in a situation where the family not only has to sue the city of Moscow, but there are so many law enforcement agencies. Is Moscow in charge of all the pictures? Or does Idaho State Police have pictures? Do other agencies have photos? Is this something that they have to go agency by agency by agency to take care of? Or do they need to make a motion to intervene back to Judge H? So now it's also a logistics issue for the families who are still navigating, I'm sure, not just grief, but also how shockingly fast this went from we're gearing up for like a 4-month trial to he pled and is in prison and is complaining because it's too loud at night. So it's a real quick turnaround. And then to have to navigate, who do I need to ask to keep these off the internet? And when you're looking at any of the victims' families, a number of the victims have siblings. Ethan Chapin is a triplet. His siblings are going to have to exist in the online world for not just their young adult life, but their young adult life and their adult life. They shouldn't be worried that some, horror show on the internet is going to DM those to them or that they're going to come across them by accident. They shouldn't have to worry. And they shouldn't have to worry if they ever apply for a job in the future and somebody Googles them that their brother's crime scene photos come up. That they shouldn't have to be concerned. And this is one of the things I didn't even think about when this pled, that this would even be an issue, because I was like, well, no one's going to release the photos. I was wrong. Yeah, I was wrong. So I hope that they don't have to go agency by agency. I hope that other agencies, if they do have photos, just deny the public records requests and then let the people that want the PRAs take them to court. I think that's the thing. Let the people who are making the PRAs take the agency or the government entity to court and then make them pay attorney's fees if they lose. That's fine. Go ahead and release the reports. That's fine. But blurred photos, I don't know if they serve a valid public interest beyond the privacy rights. And that's what we're going to talk about today, because it's a tough thing. And while the crime scene photos have some redactions to them, I don't know if it's enough. And I think it's fair to have some release that don't have victims in them and the other ones not. But again, that's how I see it. So That's not my, that's not the right screen. Where is my document? Huh. Well, that's new, but that's what my desktop looks like. But I am surprised that my docket didn't come up. Like, where'd my docket go? Why is my docket invisible? Normally, you guys would have seen it. Thank you for the compliments. I appreciate it. I'm like, why is my desktop just desktoping? All right, now I got to go back through and pull up the exact page I was on because I was all prepared and then things happened. So give me 1 second to pull this docket back up, and then we will go from there. Which is strange that it didn't show, but I had it in a different browser, and having it in a different browser apparently is going to fight with me. So let's see. Oh, CAPTCHA. I am a human. I don't need to like find somebody on Fiverr to answer the CAPTCHA for me. Why is that not working? I mean, one more CAPTCHA. I'm not a robot. I'm just streaming. It's not even robot-like. What? Some of them though, man, I'm just like, what? It's not showing my screen at all. That's interesting. Nope, not showing any of my documents. Huh. Well, that's new. Let's try this one more time and see why it's not showing up, because I don't even know what to do with that. I am kind of shocked that we're just getting nothing. Did we break it already? Probably. But in a different way than yesterday, which is really strange. Let me see if I pull up, if I just pull up YouTube, if it'll show, because yesterday this did not happen at all. Let's just go see if we can pull up. Well, we're going to just testing 1, 2, 3. Because Amy Dean in the chat said, Emily, did your computer grant you a non-dissemination order? It might have ruled against me. I feel like my computer is just like, no streaming for you. But it's not showing my documents at all, which is odd because that's never been an issue when the court, it's never been an issue when there's, well, stuff on the screen. Yeah, no, it won't show my web page at all. Megalina, if you have any suggestions, I'm here for it, because it won't show my documents. It won't show YouTube. It's showing absolutely nothing. It's full we break stuff. Just full 100% we break stuff, which I'm here for. Let me mute this so the court doesn't come back and scare the hell out of us. For all of you who are like, I did not reboot. But we're going to fix it together because streaming is dynamic. So let's just go from there and see if we can switch it. Maybe it accidentally switched to the wrong. Like maybe if we just turn it off and turn it back on, it'll fix itself. Oh, that's more promising. Okay. We tried to turn it off and turn it back on. We have a docket. Okay, well, that's fun. That's new. That's yeah. We'll fix it in post. It'll be fine. We'll fix it. It'll be fine. We'll fix it in post. Did we turn it off and turn it back on? Yes, we did. Is that going to show up for us that way? No, we're going to have to go. I think we're going to have to go full screen because the dockets are laid out really funny. So what we're looking at is the court portal for all of Idaho. This is the case with Karen Laramie against the city of Moscow. Case number, Latah County, court active, filed on the 12th. So, of course, we don't have docket documents. They would be right there if we did. So if the complaint was in the system, there would be a little document icon there. It's not. This system does not do that. You have to go through the cases of interest. This one's not populated there yet. So it's just all the things. But the summons was issued. Then on the 12th, there was an ex parte motion for temporary restraining order. There is the memorandum. There are multiple declarations in support. The notice of the attorney appearance, a response to the motion on the 14th. It was, the order was granted on the 15th, which granted the temporary restraining order, and that was officially ordered on the 15th. There were additional declarations in support that were filed on Monday, the 18th, from the Chapin family. This is filed by Maddie Mogan's family. And then the hearing is set for tomorrow on Zoom. I imagine that's going to be a closed hearing. So that's the docket. What we know from the docket is that the hearing on this will be on Zoom on Thursday, the 21st. Yes, that's Thursday. Emily, the 21st is Thursday. Let's take a look at some of the reporting. And now that we have our setup back, we can go to the interview from Bryan, and if you guys want to, which sounds like you do, so we can go take a look at that too. But let's go to some of the news reporting on this first. That worked lovely. Yes, I put it in reader mode because it's just easier on my brain. This is from News Nation. Kohberger records release blocked by judge. A judge has issued a temporary restraining order blocking the release of additional police records in the case against Bryan Kohberger. Well, I don't even know what to call it anymore. It's not a prosecution. He's been convicted. I guess the Bryan Kohberger case, I don't know what to call it because I hate connecting the victims' names with how they died all the time. I just don't know. We know who Bryan Kohberger is. We know that he pled guilty. A gag order was lifted after Kohberger's sentencing, and hundreds of case files have been released, revealing the harrowing scene responding officers found when they got to the house. The records also detail interviews with surviving roommates, inmates who were housed with Kohberger, and someone who claimed to have matched with Kohberger on Tinder. I mean, among other things, because it's also all of his colleagues, which raised a substantial amount of red flags to me. We'll go through those a different day. Temporary restraining order issued. The city of Moscow said Monday that it was served notice August 12th of a petition in the Latah County District Court for a temporary restraining order to prevent the release of additional public records in the case. Madison Mogan's mom, Karen Laramie, requested the order after redacted crime scene photos were released last week following public records requests, the city said. We're going to go to the city's statement next. Idaho's 2nd District Judge Marshall reviewed the case and issued the temporary restraining order Friday, blocking the city from releasing any images, audio, or video showing inside of Mogan's bedroom until a hearing on the preliminary injunction is held. I imagine we will see everyone else joining in this motion if they are concerned about the release of information. The judge found that major portions of what was released did not constitute an unwarranted invasion of privacy, but said portions of videos and photographs in their redacted form, specifically unreleased body cam video, could be an unwarranted invasion of privacy. Remember, even in every case we've watched, the media wasn't allowed to watch body cam footage or to stream it or to show it on camera if the victims were in those videos, which they were particularly mindful of in the Kohberger case, in the how did Murdaugh slip my mind? In the Murdaugh case, because there was a lot of body cam footage walking around Moselle that the jury needed to see to understand the way that Moselle was laid out, but also the victims were there, and those are under seal and should be. The city said the restraining order only applies to Mogan's bedroom, but that it won't release photos or videos showing inside of any of the victims' bedrooms until the matter is decided by the court. And it might be photos after law enforcement has gone through, after EMS has removed everyone, maybe. Families, quote, just want peace. The attorney who filed the lawsuit against the city on behalf of the families, Leander James, joined Banfield to talk about why they had to take legal action. They reached the point by the time of the sentencing that they actually had some closure and were able to sort of start moving on somehow. Then they got hit with this, all of this ugly stuff getting released. Well, the photos are crime scene photos. Leander said the families find the release of photos showing inside the home an unwarranted invasion of their privacy, which is the standard the court needs to decide, but that he understands the law might not see it that way. That's what the judge is wrestling with, he said, while asking the public to put themselves in the family's shoes. James said the families had tried to work with the city before suing. He said they want peace, not conflict, and urged everyone to avoid viewing the photos regardless of the outcome of the lawsuit. No one would want their family member remembered that way. No one would want their family member. No one would want these photos online. No one would. No one would. And I feel for them. So this has gone to a separate judge. I wonder if this will end up back in front of the court. So, let me take a look real quick. We're going to pull up the official statement from the city, because the city statement gives us, I think, a bit more context of what the lawsuit and the judge's order said. So we're going to go through the exact language of that temporary restraining order together and go from there. So look, when it works as intended, it's fantastic. Look at how crisp and how clean. So fresh and so clean. It's just great. Just temporary hiccups. That's all. It's fine. Press release. This is from the City of Moscow's website. Press release, temporary restraining order issued for Kohberger public records release. I also have to wonder if the city is relieved, because the city's just like, the judge says no, stop asking us. I wonder, they can just like blame it on the rain. Yeah. No, they can just like blame the manager. It's like, go complain to the court. It's chat, honestly. For those of you that now work in management, I'm sorry. But for all of you that have had jobs where you have had managers, there was something so nice to be able to just be like, yeah, I can't help you with that. My manager's over there. You can just like, you can go talk to them. Just, this isn't for me. I wonder if the city is really relieved that they can just blame the judge. Yeah, we don't have to make that decision. Just the judge decided, so you can go talk to the court. We're not giving it to you. Just go talk to somebody else. Because there were times in court when I was a newer DA when somebody would be fussing at me, and I'm like, yeah, you can go knock on my supervisor's door. Everyone was terrified of my supervisor. I'm like, you can go knock on my supervisor's door and ask, but this is what we're doing. And they would just be like, yeah, I'm good. I'm like, yeah, you can ask the court for whatever you want, but this is where we're at. And if you want me to change that decision, you know that I can't. So you can go talk to my manager. And people would be like, yeah, I'm straight with that. I'm not going to go talk to her. I'm like, it was really nice to be able to above my pay grade stuff. And then when you're the person who has to deal with it all, you're like, shit. Sometimes you just want to turn around and be like, nope, I'm still the final answer. No, nobody else you can deal with. So the city made a press release regarding the temporary restraining order. August 18th, Moscow, Idaho. On August 12th, the city of Moscow was served notice of a petition to Latah County District Court for a temporary restraining order and injunction to prevent the release of additional public records related to State of Idaho v. Kohberger. And then they listed all the different case numbers. On behalf of Karen Laramie, the mother of Madison Mogan. This action followed the recent release of redacted crime scene photos by the city of Moscow in response to a legal public records request. Just because it is a legal PRA does not mean that everything gets released. I appreciate that they redacted them. I just wonder if it would have been better to just black out the whole photo and be like, these are redacted, not blurred. These are redacted for privacy. Like, just There are like photos 9 through 20 or whatever are redacted for privacy. On August 15th, Idaho 2nd District Judge Marshall issued a temporary restraining order prohibiting the city's release of any images, audio, or video depicting the inside of Madison Mogen's bedroom until a hearing on the preliminary injunction may be held, which we know is going to be tomorrow, August 21st. Judge Marshall found that major portions of what had been released did not constitute an unwarranted invasion of privacy. So if we were to see the judge's order, I imagine that language is coming directly from the judge's order. However, Judge Marshall stated that there are portions of videos and photographs in their redacted form, specifically including unreleased body cam video, that could constitute an unwarranted invasion of privacy at this time. While the temporary restraining order only applied to Madison Mogen's bedroom, the city will not provide any further releases of photographs or video depicting the inside of any of the victims' bedrooms until the matter is fully reviewed and decided by the court. I appreciate that the city's like, nothing else is being released. Nothing's being released until the court decides it. I think that's fair. Also, I don't know if... I just don't know if the public records request entitles you to crime scene photos that the victims are in, because even after trial, you wouldn't get them. So when people are asking for a PRA of all photos, all video, all whatever, I think the city has some discretion to say, these are redacted of any images of the victims. But people are asking for everything, and it sometimes feels like there's a clamor for people to say, oh, we got these records first, and we're going through them first, and we're putting them out first. The urgency doesn't always lead to conscientious decision-making. So with me, I am going through the documents, and I will summarize the things that we have learned without all of the details down the road. Do we need to do it tomorrow? No, we don't. It's going to be fine. But treating it like it went to trial just makes the most sense to me. I wish I had the judge's order. I'm going to work on getting that because I really just want to see what the court says. And then with that, there were reports that came out early this morning or late last night. I don't remember. It was late for me. So I don't remember if it's late last night or early this morning. But reports came out that the Chapin family had joined in this lawsuit, and we saw that on the docket as well. Let me just pull this up real quick because we'd already seen that on the docket. Let's see if we can get to just the text of the thing. This is coming from, what outlet are we with? KXLY. The Chapin family joins request to keep graphic Moscow murder crime scene photos hidden. Sealed is probably the word I would have used. Hidden somehow sounds a bit nefarious, but I think I would have used sealed, but that's just me. Again, I'm not a journalist. I'm not a reporter, and I'm not looking for the most clickable through line. I'm looking for the most accurate one. Moscow, Idaho, a second family of one of the University of Idaho students murdered in 2022 has joined a request for the judge to keep some crime scene photos from being released. Agencies released some of the photos from the Moscow crime after Bryan Kohberger was sentenced for the murders. The photos did not show the victims, but did show the home in the morning after the murders, including bloody beds and walls. The photos were shared by some news agencies and by online true crime accounts on social media. 4 News Now did not air the photos at this time, as news managers determined it didn't shed any new light on the case and had the potential to do more harm. Yeah, I think so. And the thing is, not everyone runs their content through someone else, right? Because people aren't working in newsrooms the way that they were. But yes, it went to the manager. Oh, some of you are asking about background noise. There is a vacuum in the background. It's Wednesday, so there is a vacuum in the background. So for those of you that are like, what is that? It's vacuuming. Yes, Yes, I am sorry. I am sorry it is loud, but vacuuming. But I like no, you have to talk to the news manager. So I agree with them that it would not shed any new light because it's already written. Then again, you know my feelings on this. I lean towards sealing crime scene photos that have the victims in them. It goes on to say now some families have expressed concern that more photos will be released showing the victims' bodies, especially if there is body cam that they're worried about that hasn't been released yet. Madison Mogen's mother filed a lawsuit in Latah County to stop the city from releasing graphic images and videos. Laramie's attorney, Leander James, said, quote, he was put in prison for the rest of his life. They could actually breathe a little and travel a lot, and then they're hit with these ugly photographs. The prospect that they're being put out there, some were put out there without us even being given notice. James filed the request last week. Quote, I understand that this is public interest, and I understand the First Amendment because the media has a First Amendment right. I appreciate when the media says we actually don't find this to be particularly newsworthy. We're not putting out the photos. But it is what it is. But there's an exception in the law when it's an unwarranted invasion into the person's personal or the family member's personal privacy. In this case, you don't get it. You don't get the photos, not like you don't understand. I agree. But then again, I'm going to agree. Friday, a judge issued a temporary restraining order halting any images, audio, and video of the inside of Mogen's bedroom until a hearing can be held. And then the city of Moscow, we just read their statement. And that's really all the update. Since then, they say Stacy and Jim Chapin have written declarations in support of the motion. A hearing is set for Thursday. So we'll see that on Thursday. Well, we won't see it. We will hear reporting of it on Thursday. I think anything with the victims in it should not be turned over. If there is, and some of the crime scene stuff, even in Murdaugh, wasn't turned over. I hope the judge takes a look at it. Like if this was filed in trial, would it be sealed or not? And if it would be, then it stays sealed. The reports are out there. There is transparency for people to look at what the evidence is. The crime scene has been thoroughly described in police reports. There's a ton of police reports, and those have been made public. I don't think there's any overriding public interest in every single photo, every single body cam being released. And it wouldn't have been after trial. Some of it would have been seen if it went to trial. Some of it would not have been. So fair on that. I hope the judge parses it, leaning more towards sealing than not. Let's see if there's anything else on that. I'm going to look at a few questions and see if there's anything else on that. If we want to go through the lawyer's statement, we can, though I think we've pretty well covered it in the articles that we saw. Because I think we're really there. M said, I haven't seen any photos from the Murdaugh case. I think the only ones that I really remember are the maps and like the locational photos around Moselle for the trial. There were some crime scene photos that were a part of the trial that were shown, but not a ton. And then the videos, like the Bubba Come Here video and those videos, but those aren't crime scene videos, but they were evidence in the case. Crime scene photos got leaked, but I did not go seek them out. I don't know how online those got. But I don't go looking for them. I don't need to. I don't want to. And I think the less people look for them, the less people are inclined to put them out. So that's what I'm optimistic for. I'm going to look for a few more questions and then we will move on to the TikTok psychic case. So let's see. AC said, wanting to fight hard for exploitative photos is morally reprehensible. AC, I am where you are, so it's hard. I understand the media's interest in the First Amendment, but also I think the reports cover it, but I am not in a media outlet. But I said this as we were going through the Diddy trial when people were trying to get the media was requesting the videos that were being showed in court. I'm like, no, No, you're in court and you can give some reporting on it, but no, there are some things that are going to be sealed in court. I'm good with it. So it's hard for me to argue the other side because there's things I just would never push for, which is why I'm not a journalist, because that wouldn't be what I was good at. And I appreciate many channels not showing them. And I appreciate the media, even if they got them, not showing them. But you can't unsee it. And if they're online, they're online. And that's tough. So let's see. And a lot of you are like, nah, we're good to move on, which I appreciate it. So we can move on to the TikTok psychic case, because that is where we're going. But yeah, Chat, you and I are all on the same page. Nimby, did I miss an update on Charlie from Dr. B? No, I'm going to save that till we get to Q&A after we get to TikTok psychic. I'm repeating myself a lot today because I am just tired, honestly. My brain is tired. It's just, I'm like, tired. Let's move on to the TikTok psychic. April O said, Emily, are you going to be going through any of the unsealed documents? I am going to do summaries of the unsealed documents. I am not, that case is incredibly heavy. I'm going to do summaries of them, but I'm not going to go through them line by line on stream. There's a lot of details in them, and because they're publicly available, I think everybody can find them if they want to, but I know a lot of people just wanted a summary of like, what did we learn and what would we have seen come in at trial? That I will do. It's going to wait until after Adelson, but I'm reading through those slowly. If I hadn't been traveling as much for DCI this summer, it might have gotten done sooner, but this is the new information we learned. This is the type of evidence they would have shown, but not a lot of the more graphic details that we're going to just pull right out. So that's my thought. Let me know what you guys think. But since we're in Idaho, and since we're talking about Idaho, we need to talk about the TikTok psychic. I'm going to put up a poll because we have new law nerds here who might not know this case. So we're just going to start a poll real quick. Let's see. Yes. All right. I'm just putting up a poll real quick to see how many of you have heard of this case. Don't worry. We'll do a road so far. Don't you worry. Whether you've heard of this case or not, we're doing a road so far. Buckle up. So we should swoop. We should swoop. We need a swoop. We should swoop. As the Bryan Kohberger case came to an end with his somewhat surprising plea deal and sentence to multiple life without parole sentences, one of the things y'all asked me quite a lot about was, what does this mean for the TikTok psychic defamation case? Some of you are going, what is that? Well, a TikTok creator who has argued throughout the course of this federal defamation case that the evidence that she relied on was her own clairvoyance and tarot card readings, and that the court was disrespecting her and her freedom of religion by telling her that that was not objective evidence that could be used in trial to prove that the things she said about a professor from the university weren't defamatory. We are deep in what will happen to her now that Bryan Kohberger pled guilty, because remember, the TikTok creator has alleged that this professor orchestrated the murders, called her a murderer, among other things, alleged that she had a relationship with a student, which is, because of that student-teacher relationship, improper and strikes at the heart of one's employment. Those calling someone a murderer and alleging a workplace inappropriate relationship, both of those things were found by the court to be defamation per se at motion for summary judgment. So, Emily, why are we still here? Well, after the motion for summary judgment, the TikTok psychic made a whole bunch of motions trying to get the court to reconsider. But, Your Honor, you don't understand. Same arguments I've made before. But, Your Honor, you don't understand. More information that came from the criminal case that showed that the victims were scared. And that substantiates the TikTokers' videos that shows that they are there for objective evidence. But, Your Honor, I need another judge to decide it. And the court said, no, 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 no. Liability has been determined in this case. It has been determined that the TikTok creators' statements were defamatory. Period. The TikTok creator is still representing themselves pro se in federal court in Idaho. The university professor has been locked in this case since it was filed in 2023? So here we are getting ready to go to trial. Emily, if there's trial, how do we do that if liability's already been determined? Damages. The judge added punitive damages, which are the punishment ones, which are the find out damages. They are the definition of the find out damages because it doesn't have to be actual damages. Actual damages would be things like, due to proven emotional distress, I missed this much work on stress leave because of the things that were said about me. So you can quantify how much time was spent off of work due to a leave like that, or how much you have paid in attorney's fees if attorney's fees are part of what you can claim. There are actual damages that are quantifiable. But punitive damages are the find out damages. Punitive damages are the how fucking dare you damages. Punitive damages are the jury gets to say, oh no, we're not doing this. You can't just run around accusing people of murder as the conductor of some sort of fucking clout circus in the middle of a devastating event for a community. No. So the judge in Idaho, you have to add punitive damages by judge, and the judge added punitive damages. So now it needs to go to trial on the amount of damages because, surprise, surprise, the TikToker refuses to participate in mediation with the court where an amount of damages could just be set, but she won't participate in court-ordered mediation. Based on her filings, it seems that she won't participate in court-ordered mediation is because she thinks the court is mocking her religion by not saying that her purported clairvoyance is objective evidence. The court has been more patient. The court's patience is getting a little bit thin, but the court has been more patient than most federal judges would be and than I ever could be. I lost my patience at like the first filing. The court has tried to order the TikToker to participate in mediation because you could set an amount of damages if everybody could just talk. She refuses to participate. So the judge made an order for this case to go to trial, and the order is incredibly specific. So we're going to go through that specific order and take a look at what the judge has to say. Shockingly, though I'll check again after I do this, the TikToker has not yet responded. I imagine that what we will see is another motion saying, but Your Honor, no, you don't have authority over me or some shit. I'm waiting for the court to just start screaming, respect my authority. Where is it?
Respect my authority!
I'm just waiting. I'm waiting for the court to just start screaming, respect my authority. So, Ocean Beach said, why isn't the judge issuing a bench warrant? Because you can tell people to participate in mediation, but you can't really force them to actively participate. If you've ever argued with a hungry, tired toddler, you can encourage them to change into clothes to go to sleep, or to take a deep breath because they'll feel better, or to just get in the bathtub. You can encourage it, but it's not easy to wrestle a tired, hungry toddler. And this is kind of the circumstance where the judge can say, you need to participate. But even if the judge could mandate somebody to show up on a Zoom call, you can't actually make them participate because they can just sit there and be like, no. Make me. And then what do? Well, then you have a trial on the damages. And that's what we're talking about today. Because the judge in docket number 100, did you see that? Did you see that at the top there? Here, docket number 100. Order setting trial. Go to trial. I think this is probably what the party is thinking.
Not today, Judge.
This is just,
Not today, Judge.
that's what it is. That's what it is. Janet B said, why didn't she get contempt of court? Because the court can't really order you to participate and make you actively participate. They can make you show up on a Zoom call, but they can't make you engage in meaningful conversation. The court has resolved all motions to date. Discovery is closed and the case is ready for trial. And to date, this was filed on August 12th, 2025. Trial date. A 4-day jury trial is set for Tuesday, February 24th, 2026, beginning at 9 a.m. Pacific time. Because in Idaho, you gotta pick, because some of it's Pacific and some of it's mountain, and it's confusing. I see some of you already say you need to go. If Corey Richins is in trial, I can't. Because Corey Richins, if Corey Richins is not in trial, then I will. But I've got thoughts that I'll give you at the end of this. I'll wrap up at the end of this. I have thoughts. A 4-day jury trial is set for Tuesday, February 24th, beginning at 9 a.m. Pacific in Coeur d'Alene. Yes, Idaho, footnote 1. Footnote 1. Plaintiff's complaint was brought in the Moscow, Idaho division and demanded a jury trial. There is no longer a federal courthouse in Moscow, Idaho. Therefore, unless otherwise ordered by the court or agreed by the parties, not a fucking chance, the jury trial will take place in Coeur d'Alene, Idaho. Coeur d'Alene, thank you, chat. Unless otherwise ordered, trial on the first day will include 2 15-minute breaks, a 1-hour lunch, and will end at 5 p.m. Beginning day 2, the court will follow a compressed trial day, which shall begin at 8:30 a.m. and end by 3 p.m. with 2 15-minute breaks. Pre-trial conference dates. A pre-trial conference is scheduled to take place at 10 a.m. Mountain Time, not to make anything confusing. 10 a.m. Mountain Time on February 5th, 2026 to discuss and resolve insofar as possible 1. Legal issues remaining in the case. 2. Evidentiary issues. 3. Trial logistics, including exhibitees and witness lists. 4. Any other matters pertaining to trial. On or before January 29th, 2026, the parties shall communicate and reach agreement on as many items as possible. Your Honor. Every time the plaintiff's lawyer says that she tries to confer with the defense attorney, she says that the defense attorney kind of goes meh. So I don't know how that's gonna go. But all right. The parties shall reach an agreement, including stipulations related to the parties' proposed exhibits. This should include stipulations on foundation, or other evidentiary matters. Sure. Even if there is disagreement as to whether a document should be admitted into evidence based upon relevancy issues, the parties should be prepared to discuss with the court those items over which counsel and party disagree. The pretrial conference will be held via Zoom. Counsel and party to receive video link via separate notification. That I will try to listen in on. Persons granted access to remote proceedings are reminded of the general prohibition under federal law against photographing, recording, and rebroadcasting the court proceedings. Oh, I'll definitely listen and report back. A second in-person pretrial conference is scheduled to take place at 10 a.m. Pacific. Not to get confusing. 10 a.m. Pacific on February 23rd, 2026 to discuss any outstanding issues ahead of trial. What are the odds on whether or not this defendant shows up in person on February 23rd at 10 a.m. Pacific? Because I'm not confident that that's going to happen at all. Dauber motions. We all know what those are. All of you are like, yeah, I don't think she's gonna show up from wherever she's living. Texas is where they've been sending documents. Dauber motions. Rule 702 motions shall be filed with the court by September 2nd, 2025. Well, that's coming right up, it feels like. Responses to any Rule 702 motions shall be filed with the court by September 16th or within 14 days of the filing of a Rule 702 motion, whichever is earlier. Replies to any Rule 702 motion shall be filed with the court by September 23rd, 2025, or within 7 days after the filing. Any response to a Rule 702 motion, whichever is earlier. Witness lists. The parties shall exchange witness lists and file copies of those lists with the court on or before October 7th, 2025. The witness list shall contain the information listed in Federal Rule of Civil Procedure 26A3A and B and shall include a full summary, not just the subject, of the witness's expected testimony. A full summary. And there's a footnote where the court says instructions for formatting the witness and exhibit list can be found on the court's website. That's not included for the benefit of plaintiff's counsel. That is included for the benefit of the defendant who is representing herself. Do it this way. But the witness list, including a summary of the testimony, not just the subject matter, has sent me. Because her defense so far seems to be, but people on TikTok asked me to do a reading on this case. And it's my opinion, not defamation. So, exhibit lists and exhibitees. All exhibit lists shall be filed with the court by October 7th, 2025. No later than that same date, the parties shall exchange all trial exhibits. But shall not provide them to the court until the following dates. By February 16th, 2026, the week before trial, counsel and party, defendant is not counsel, counsel and party shall provide the court with a copy of the exhibits in electronic form, underlined, for the court's personal use during the trial. This is so federal. On or about or on or before the morning of trial, counsel and party shall submit a set of original pre-marked exhibits in a binder. The exhibit list shall follow the guidelines set out in Local Rule 16.3F to the extent it is not inconsistent with this order. Merge the two and give me a list and a binder and then a separate stack of exhibitees. The exhibit list shall be prepared on the form provided by the deputy clerk with sufficient copies for the judge, the deputy clerk, and the staff attorney. That's the judge's attorney. Exhibit numbers 1 through 499 shall be reserved for plaintiff exhibits. Exhibit numbers 500 through 999 shall be reserved for defense exhibits. Exhibit number 1000 plus shall be reserved for joint exhibits. Number sequentially, start on your mark. Like, get to your dot. Counsel and party shall review their exhibits, determine any duplication, and jointly mark and stipulate to the admission of those exhibits that both sides intend to offer and rely upon. Jury instructions. All proposed jury instructions shall be filed with the court by October 7th, 2025. The proposed jury instructions shall follow the guidelines set out in Local Rule 51.1. Additionally, counsel and party shall email a clean copy of their proposed jury instructions to the court in Microsoft Word format at email address. Proposed verdict form. The parties must submit a proposed verdict form with their proposed jury instructions. Proposed voir dire. Proposed voir dire shall be filed with the court by October 7th, 2025, and shall follow the guidelines set out by Local Rule 16.3e. Trial brief. Now everybody's like, how much work is it to be a lawyer? This is this. Actually, most attorneys have their paralegals do this, but not everybody has paralegals. But yes, this is a ton of work. Trial brief. Emily, did you enjoy making binders? Well, only when the copying machine cooperated. When it didn't cooperate, I was frustrated. But when we got there was a period of time when we got the new copy machines that are now going to be very old, but we got new copy machines that would also 3-hole punch at the same time. I cannot tell you how much better my life got when I was not copying and 3-hole punching everything. It was like, you know, the angels all sang in the heavens because it would copy them out and collate and 3-hole punch. I was like, my life has never been better. Tell me you worked in government work when you get excited over a copying machine that works and makes your life better. Yeah, because then you go to work feeling like your day is, well, office space over and over again. You just want to fight with the fucking copier. Rebecca said, worked for a company who specialized in legal copy work. I hear you. Right? Proposed voir dire, filed by October 7th. Trial brief. Trial brief shall be filed with the court by October 14th, 2025. And shall follow the guidelines set out in Local Rule 16.3b to the extent it is not inconsistent with this order. Motions in limine. I'm so ready to see these filed. Is that bad? I'm so curious as to how this is gonna go. Y'all, the fact that this is going to trial is wild. Motions in limine shall be filed with the court by October 14th, 2025. That deadline is coming right up. Responses to any motions in limine shall be filed with the court by October 21st, 2025, or within 7 days of the filing of a motion in limine, whichever is earlier. Replies to any motions shall be filed with the court by October 28th, or within 7 days after the filing of any response to any motion, whichever is earlier. Trial procedures. The court will generally control voir dire. Counsel and parties voir dire will be limited to 30 minutes per side. Oh my God. Federal court. The lawyers only get the lawyers and the pro se lawyers. 30 minutes, that's it. Counsel and party are cautioned not to repeat questions already asked by the court or other counsel/party, and are advised that the court will not permit voir dire which appears intended to influence the jury rather than explore appropriate concerns with a juror's ability to be fair and impartial. The court's already laying the groundwork. The court's like, I see where this is going to go. I see how this is going to go, and we're not doing it. No fuckery. The court's adorable in talking about this like this trial is going to go forward in a normal linear process. Because, well, we'll just see, won't we? What's going to happen? Ultimately, a jury comprised of 8 individuals shall be selected. Civil case, federal court, Idaho. All jurors selected will deliberate on the verdict. Each party shall be allowed 3, that's not very many, 3 peremptory challenges during voir dire. Counsel and party shall exercise good faith in attempting to reach a stipulation on undisputed facts and admission of exhibits. There are a lot of undisputed facts in this case because it resolved. But I imagine when we get to damages, the TikToker is going to go, nuh-uh, she wasn't even fired. Which would be a stipulated fact because she wasn't in fact fired. But anyway, exercise good faith in attempting to reach a stipulation on undisputed facts and admission of exhibits. During the trial, the jury will be in the box hearing testimony the entire day. Ugh, my nose. Excuse me. During the trial, the jury will be in the box hearing testimony the entire day. During the time the jury is in the box, no argument. Beyond 1 sentence evidentiary objections. No argument beyond 1 sentence evidentiary objections shall be allowed to interrupt the flow of testimony. Almost all objections should be stated in 1 to 3 words. Hearsay, asked and answered, irrelevant, etc. Someone's going to need a rules of evidence stat because most going through law school take a full year of evidence and then other classes that touch on evidence because everything kind of interweaves with evidence. So a lot of your other coursework is interwoven. And then you generally work with attorneys in the summer. And if you're working in court at all, you start to learn these things. Evidence is really hard to learn if you're not actively working in it. This is not an easy thing to do. But again, ask your lawyer. So Rachel ID said, and Civ and Crim Pro. Yep. And if you're interested in going into criminal, most of the people I went to law school with, we also took like advanced criminal procedure and then additional classes on evidence. Because, well, it's like the most important thing. Matters that need to be resolved outside the presence of the jury should be brought to the court's attention as soon as possible and preferably prior to an issue arising during trial. It's like you need to foresee it. Too easy? No. You need to foresee the issues, which if you work in law long enough, you can absolutely foresee the issues, which is going to require a lot of heavy lifting on the part of plaintiff's counsel. Matters that need to be resolved outside the presence of the jury should be brought to the court's attention as soon as possible and preferably prior to the issue arising during trial so that the court can consider and decide upon such matters during a recess or before or after the trial day begins or ends. Where the need for such a hearing cannot be anticipated, the court may direct the examining counsel or party to avoid the objectionable subject and continue on a different line of questioning so that the objection can be argued and resolved at the next recess. To avoid late night sessions, counsel and party are advised to bring up all anticipated evidentiary questions in their pre-trial briefs. Examples of improper questions. I can't imagine that the court puts this in anything that doesn't go to a pro se attorney. Or a pro se party litigant. Because you're not writing this out for lawyers. The court's really trying to be helpful here, which is wild. Examples of improper objections. I object to that question, Your Honor, because I am sure that Charlie Witness did not read that document very carefully before he signed it. I love that he picked such neutral objections because I wouldn't pick something so neutral. Objection, Your Honor, nuh-uh. They can't know what I'm thinking. I object, Your Honor, because Charlene witness has already testified that she can't remember. These speaking objections would suggest an answer. Counsel and party shall have enough witnesses ready to ensure a full day of testimony and shall communicate with opposing counsel party and the court a list of the next day's anticipated witness or witnesses. If witnesses are unavoidably delayed, counsel and party shall promptly notify the court and opposing counsel or party. When counsel or party announces the name of a witness called to testify, the court or clerk will summon the witness forward to be sworn. The clerk will administer the oath, and after the witness is seated, ask the witness to state their name and spell their name for the record. I will then indicate to counsel/party that they may inquire of the witness. I cannot imagine that the court lists this out for every attorney before them, because this is the training wheels version of intro to trials. It goes on. Please do not address parties or witnesses, including your own, by their first name unless such familiarity is clearly appropriate and is not likely to be offensive to the witness or any juror. In case of doubt, don't. I don't think I've ever seen a federal judge just write, in case of doubt, don't. I've never, period. Just period. Your client and your witnesses should be instructed that they should always refer to you and opposing counsel party by last names. This is like basic decorum. You are responsible to advise your client. Advise oneself. You are responsible to advise your client, your witnesses, and everyone associated with your client to avoid all contact with jurors. This prohibition includes seemingly innocuous behavior like riding an elevator with a juror, saying hello to a juror, or even acknowledging the juror's presence. It's so awkward, but I appreciate judges that remind the jurors of this and remind the jurors, look, if the lawyers are in the elevator and you get in and they get out, they are not being rude. They are not supposed to interact in any way. If you say good morning to a lawyer because we are used to saying good morning in our society and they do not answer back, it's because they are not allowed to. So just don't talk to the lawyers. They won't talk to you. It keeps it from being awkward, but it's awkward, but don't. Don't. They don't exist. On the clock. As of now, plaintiff is allocated 50% of the trial time and defendant is allocated 50% of the trial time, which will be determined once jury selection is complete. The court will keep track of the time each party uses and will adjust the number of total hours expected for trial based upon what happens at trial each day. The court will provide reports to counsel and party at the end of each day regarding counsel parties' use of time and, where applicable, any adjustments to the total and allocated hours. The clock is running on a party conducting opening statement, direct, cross, and objections that are unsuccessful, and closing. Very much the way the clock worked in Depp v. Heard. Like literally like a chess timer. If you make an objection and you argue that objection and you lose, that time counts against you. Settlement. The parties are ordered to notify the court on or before January 30th, 2026, that the case has either settled or will definitely go to trial. The parties are once again encouraged to discuss the possibility of participating in a judicial settlement conference or mediation. Please discuss the possibility of participation. If you would just talk, this would probably settle. Please. The parties are once again encouraged to discuss the possibility of participating in a judicial settlement conference or mediation. If the parties wish to proceed with the judicial settlement conference, be aware that coordinating a settlement conference judges schedule to participate in a settlement conference is extremely difficult. Therefore, the parties must attempt to schedule a settlement conference well in advance of any impacted deadlines. Every time the court has asked the parties to do this, the lawyer for the professor has come back with, there's no interest from the other side in doing that. Like, the other side doesn't want to do that at all, Your Honor. I'm going to double check the docket just to see, because last night there was nothing, but who knows? I mean, we've gotten through almost half a day here, depending on if we're in Mountain Time or Pacific Time. But the defendant hadn't responded to this yet. And I'm just kind of waiting for a response, because I'm sure the response is going to be, but Your Honor, I never agreed to go to trial. What do you mean we're going to trial? What are we even going to trial on? I imagine it's going to be there's going to be some kind of fuss over it, but who knows? Maybe there won't. Nothing new on the docket as of yet. So, the TikTok defamation case is going to trial for damages only in February 2026, at exactly the same time that the Corey Richens case is going to be going to trial. But if anything changes, I will go to Idaho. It's going to be cold. I have cute boots and a jacket. I will go to Idaho. I will go to Idaho. I volunteer. If Corey Richens is in trial, though, I cannot go to Idaho. But God, I want to. Look, it's not like I'm a Tuesday and would have to fly to Korea to follow this. I will go to Idaho. I will go to Idaho. But again, if Corey's in trial, we're covering the Richens trials. No, I have actual boots, not Ugg boots. I have snow boots with the fur. I do. I will go. I will go sit in federal court. I 100% will. But we'll see. I don't know if this is going to go to trial. It's supposed to go to trial. Once we get to defendant has to go to Idaho, I'm not sure how that's going to go. But we're going to wait and see. I'm going to put the Zoom conference on my calendar. It can't be streamed, but like I've done with other conferences, I will take notes and report back to all of you. I'm very interested to hear. And at the last conference that I listened in on, the defendant did at one point say, Your Honor, I didn't see that question coming. And I've never been so happy that I was on mute, because I fell out. Oh, for all of you asking about Atosi, I'm sorry if I've pronounced it. I don't pronounce things right. And we've met. He's lovely. But yes, went to South Korea to see the Johnny Somali case. Oh, I am aware of cases that I'm not covering. I am. I keep an eye on his reporting. But Idaho's not a heavy lift. Maybe he'll go to Idaho. Do you think? That would work. But I don't know. When we get to that in-person hearing, I don't know if she's going to go. I don't know if she's going to go. I don't know. I'm waiting to see what we see on the docket after this. We've got some time. We've got some time left before this. We'll see. I'm not, I need a magic 8-ball. Outlook does not look good would be the answer I would give if I had a magic 8-ball. I imagine that's the answer the magic 8-ball would give me too. Like, Outlook not good on whether or not this pro se defendant shows up in Idaho for this damages trial. What would happen from there would be interesting because the judge would have to make a court order, then find her in contempt. Amanda said, Emily, I feel like reports said she's not in the country, so is there an issue with serving her? No, there's no issue with serving her because she's already engaged in active litigation. She's been served. She doesn't have to be served again. She's on notice. So it doesn't matter where in the world Carmen Sandiego is engaged in active litigation. So it doesn't matter. It's on her to get back to the case. G Mommy says, what if she responds with she can't afford the travel? Well, she has the option of participating in mediation, but she's in litigation. Beerly said, Emily, as a prosecutor, what would you be recommending if she doesn't show? I didn't do civil law. It's too wishy. But I imagine the court would issue a court order and then find her in contempt. And then if the court issued a court order and if she was found in contempt of that court order, the court would probably start a financial tolling and say, okay, for every day you don't show up, it's $5,000, whatever the court wants to do, and start a financial tolling. The reality of the situation, unfortunately, is if there's nowhere to go collect those assets from, it just becomes another thing that the plaintiffs have to go do. And at the very beginning of all of this, the plaintiffs got a default judgment because the defendant never responded. And the defendant came in and was like, I swear I'm going to respond. I'm going to follow the rules. I'm going to be in this case. Please remove the default judgment and let me actively participate in this litigation, and said, I will follow all of this. But we'll see when, push comes to shove, if that's what's going to happen. I'm not sure. Bone Arrow 82 said, could she get arrested? It would be unlikely in this civil case if she is found in contempt and if financial tolling doesn't do anything, if she is not in the jurisdiction of getting a cross-jurisdiction body attachment bench warrant to bring her into court. That would be difficult because it's not a criminal case. It's a civil case. The reality is, if she doesn't have any money, you end up in the place where the professor could win. The professor's already won liability. There's already a ruling that stands that the professor has been defamed. Next would be getting a judgment for a sum of money. Next would be then trying to collect on that judgment, which also can take time and energy and lawyers and the rest of it. It's frustrating, but at least that judgment would be out there in case anything happens down the road. And you never know, if the TikToker tried to sell this story, I don't know who would be buying, but tried to do something or won the lottery or whatever, this judgment would still be out there. So it's worth going to the judgment, but it's still going to be difficult. And that's a difficult push-pull because, well, it stopped the TikToker who's no longer on TikTok. I don't know if they are on other platforms. I don't look because I don't think the attention is needed, but that's also a difficult thing, right? Because if someone's not making any income, then there's no way to make it right when our system in civil particularly is based on stop doing that shit or pay. or go to jail. I mean, not in the civil system, but stop doing that shit or pay. That's really what the system is based on. So if there's no money, it becomes difficult. We will see. I'm just waiting for the other shoe to drop on whether or not she's going to show up to trial, but I am keeping keen interest in that. We've been looking at this case since it was filed, which I think was the end of 2023, but it could be the end of 2022. So now I need to pull up the original filing because I don't remember off the top of my head, but it was filed in like December. So let me see where the first filing is in this. Where is docket number 1? There's docket number 1. What day was this filed? Oh, December 21st, 2022. I was way off. December 21st, 2022. I had forgotten it had been that long. So the professor has been dealing with this case since filing it then. Now that the Kohberger case is done, it doesn't really, and this is the question I got a lot, it doesn't impact this defamation case because the defamation case liability's already been found. What you know at the time you say the shit is what's important. And what she knew at the time, she was saying the shit is what matters. And when it came to summary judgment, the TikToker defendant didn't have any objective evidence that she had facts to show that the professor was a murderer and had engaged in an inappropriate relationship, because there are 2 statements there. And a university professor involved in a relationship with an enrolled student is against all of the work handbooks. It's something you can be fired for. So she's been dealing with that, and the media blew up those TikToks. I don't know if this lawsuit ever would have gotten filed if the media hadn't been covering all of those TikToks leading up to the time that Bryan Kohberger got arrested and before Bryan Kohberger got arrested. It gained so much attention that Moscow PD had to put out a statement saying that this is not the lead we're following. And now that there's evidence being released in the Kohberger case, at least now those headlines for the professor lose some of their weight because so much more is known. But they're still out there, and it still doesn't undo the emotional trauma of having people leave death threats on your work phone, trying to find your personal cell phone. Like, it doesn't undo the scars of internet harassment because the university professor had the audacity to have a job and then get targeted by someone on TikTok because their photo was on their department website because they were the chair of their department at the university. And those headlines will never go away. So how do you undo defamation like that other than hope that when the truth comes out, people will pay attention to it? There aren't still headlines on this case. There aren't. There should be, but there aren't. I don't know if anyone other than creators even covered the summary judgment and the fact that the professor won a summary judgment motion. I wish that all the outlets that had published headlines about this were required to go back in and update their site with and on this date, this professor won a motion and it was found that the TikToker was liable for defamation. But that is not required. I wish it were. But it just sucks. And it's hard to find recompense for that. But one hopes that the judgment and the win in court where somebody says this is defamatory overrides it. It will, at least for future jobs and things like that. But it's tough. And it doesn't undo having your life upended. At the same time, like the professor's life was being dug into and upended leading up to in time Kohberger being arrested. So it's while there was so much upheaval in Moscow and in the university. And that's really, really difficult when people are targeted, people who aren't public figures and are just, again, picked off of a website. And the clout circus is not mine. All of you are like, clout circus, 10 out of 10. It's not mine. That was the attorney, Wendy Olson, that put that here. I'll see if I can find it here. That put that in the initial filing. Let me see if I can find where that was. There are a few lines from filings that stick with me. And Monuments to the Gods of Speculation is one of the top ones. But Clout Circus is definitely on there. All right, it's not in this document. Let me look one more place. Because it was, for those of you new to the case, it was a 10 out of 10. Let's see. It might be here. No, that's not it. I'm just going to go through my documents real quick to see if I can find the response to the motion for relief from default. I wonder if it's here. And if I can't find it, I will look for it another day, but it's in one of these. No, it's not in that one. What? Emily, we're going to stop looking. No, we're going to just do two more, just two more. And if they're not in there, I'll go look for this separately and I'll let you know in the app because I want to find it. I also, as we go to questions, need to find, I need to remember to answer what Dr. B had to say about periodontist versus oral surgeon, but it was in one of those really early on filings. And I wish I could just search my entire drive. I don't know if I can. Nope, it's not there. All right. I will keep looking for Clout Circus and find which filing it's from and keep you guys posted in the app. Otherwise, I'm going to be here all day searching through each of these filings. But it was one of the early on filings where the default had gotten entered because the TikToker ignored it. And then the TikToker came in and was like, no, I'll behave. And then the professor was like, you should just grant the default. The creator is going to keep turning this into a clout circus online, which is what she did with the cease and desists. So Nightshade Winter asked, does the professor still work at the same university? By all accounts, yes. The university, it seemed, was, from the reports I could find online, it seems that the university was incredibly supportive of the professor in navigating fuckery, which not all employers have the fortitude to do, truly. So I was happy to see reports of that, but we have not seen any reports that she had negative impacts at work. So with that, I know it feels like a shorter stream, but we are going to be getting into trial. I'm going to check in real quick on reports from the Adelson case so I can give you guys a little bit of an update. We're not going to be watching jury selection today, except the judge did get I'll play that real quick. The judge got a much more robust answer to his questions this morning, and it was kind of adorable, and I loved it. But they're probably at lunch or just at the end of lunch, but they're still picking a jury today, and it's literally same as yesterday with the judge saying the exact same thing that he did yesterday and giving them all the same rundown that he did yesterday because they are just seating and yeeting. Let's see if there's any updates from today. Give me 2 seconds to look for that, and then we'll keep going. Let's see. We didn't get the Dr. B update yet. I'll swoop us to Q&A and we'll talk about it real quick. Let's see. Where's Adelson day 2? There's got to be something. All right. Adelson day 2 updates. Here, I'll swoop and we'll give a quick update. We're just going to grab this from the Tallahassee Democrat. They have a reporter in the courtroom, so we will grab it from there. Let's swoop. Where is my swoop? There it is. Swoop. All right. They had 63 jurors yesterday. at the end of the day. So, and those 63 are to cull down like the cause issues. And so they're trying to get to 100. I think they might be able to do that today unless there's a lot more people today that know about the case, which would seem unusual. It seemed that the people who knew about the case were like, yeah, I know about the case. And everybody else was like, what? And it seemed that there were not that many that knew about this case. So let's look at updates from day 2. Look at how crisp and how clear. Oh, I love it. It's so good. Donna Adelson trial day 2, live updates. Court makes strides in jury selection from Jeff Burlew. Let's see. Jury selection resumes for the second day. Roughly 300 people have been summoned for jury duty. Leon Circuit Judge, I don't know why those words aren't making sense in my brain, but Judge Everett and the lawyers for the state and defense are questioning each of the juries individually behind closed doors as part of the pre-screening to find out how much media they've consumed about the case, right? So you don't impact the rest of the jury. You don't want to taint the pool. We're going to just let it go. We're going to let it go. We're going to let it go. So jurors who don't know much or haven't made up their mind return on Thursday for group jury selection, which is the more typical voir dire where they ask questions about can you be fair and the rest of it. A lot of that's going to be covered here. On August 19th, 64 out of 102 potential jurors were asked to come back for Thursday. So 62 is great. They want to get to 100. Done. Pretrial publicity has been a major issue raised by the defense in previous Markel trials. The defendant's son, Charlie Adelson, who was convicted in Markel's murder in 2023, claimed in his appellate brief filed in May that Everett erred in not granting a defense motion for change of venue.
Survey says.
I'm just going to take an aside real quick. Just a quick aside. The way Judge Everett has handled change of venue is the way I personally think change of venue should be handled in a lot of cases. Judge Everett said, and this is what they would have done in the subsequent Murdaugh cases, but what Judge Everett said was, we need to start picking a jury. And if we get in here and we get 1 out of 10 that hasn't heard about the case, then we need to take a look at if we need to change venue. But we need to pull in an actual veneer of 300 jurors. And if from 300, we can't find 12 that have not heard about this case, but not made up their mind about this case, then we need to open up the discussion about change of venue. He does not do it in absentia or in vibes. He waits to see. And what we're seeing here is that a handful of people came in and were like, yeah, I heard about the case. And some people knew the case well, but it was a few. It was not the vast majority of jurors. So from 102, they got 64. And some of those are going to be like, I don't know if I can sit on this case for other reasons. At the heart of this case, even though it is not between marital partners, Wendy Adelson and Dan Markel, it is still a familial relation case. And it is actually more likely 10, almost 11 years removed from this case, that people would have more emotional responses to the fact that this is more of a domestic type case than the fact that they had heard about the case in the past. Because too many people have interactions in their lives that more mirror this case, not to this extreme. Unfortunately, some do, but not to this extreme. But I think it's probably more jurors that are like, this is a family case. I cannot be impartial in this type of case. And I imagine that that's the larger percentage of jurors. So other than that, there's a few people that were like, nah, yeah, I watched the last trial. Nope. And those people just said, which is fair. Donna Adelson's attorney also asked Everett to move the trial out of town, and though he has declined to do so thus far, because he's waiting, which I think is the way you deal with it. Markel was shot, we don't need to go through this, but Markel was shot in the head on July 18th, 2014, after pulling into his garage of his Benton Hills home. Prosecutor asks to allow evidence about changing the last name of the sons. Ooh. Look, man, They did it. They got to talk about it. Assistant State Attorney Georgia Kappelman asked Judge Everett this morning, August 20th, about whether communication between Donna Adelson and her daughter Wendy Adelson about changing her two sons' last name from Markell to Adelson can be admitted into evidence. Everett asked Kappelman about the purpose of the evidence. She replied that it's part of the motive to erase the father from the lives of Wendy and the sons. Everett asked whether there were any communications or other evidence that would show a connection between the mother and daughter as it pertains to the name change. Kappelman said there are communications between Donna and Wendy Adelson about the last names before the name change occurred. Everett asked Kappelman to provide a copy of the communication. So we're going to wait and see if that comes in and how it comes in. And that's where we're at the beginning of the day. But I think we should go to the jury coming in just real quick because the judge was so tickled. And then we'll get to Q&A because it was funny and I liked it. But I suspect if there are communications between Wendy Adelson and Donna Adelson about changing the last name of the sons from Markell to Adelson, that the court will allow those communications in because they are relevant to the motive in this case. So I think we will see that come in if there are emails or text messages of the such. Crazy Cat Queen in the chat asked, wait, there are no Markell grandparents? There are. There's actually been litigation and law changes in Florida because of this case about grandparent estrangement. But the Adelson family kept the kids from the Markell grandparents and have kept the kids from the Markell grandparents. But it's my understanding that Wendy has the kids and moved out of the state of Florida. But the grandparents did fight, and a law was passed in Florida to try to prevent this type of estrangement. So the Markell Act. Casey Cat also added that the kids are in their mid-teens now. They were 3 and 4 at the time. Yeah, it's been 11 years. And that estrangement is really, really, really tough because it's tough. Valerie asked, how many jurors have been seated? None. I talked about this a little at the beginning of stream, so apologies if I zoom, but I like the way that Judge Everett is doing this. I think it's what we're seeing in more high profile cases because he's taking the panels of 50 morning and afternoon, narrowing them down for cause and for media and screening them one by one. The people who are yeeted or told, thank you so much. The people who are passed to go through to the veneer are told to come back on Thursday. On Thursday is when they are going to seat jurors. So 50 in the morning, 50 in the afternoon, initial screening yesterday and today. Thursday, they're going to start seating jurors. And that will go pretty quick once they've done this initial screening. But then you don't have like a juror sat as juror number 1 sitting there through all of the other jurors. If they're in the morning panel and they pass, they get told to come back Thursday. Instead of sitting in court all of Tuesday afternoon and all day Wednesday. I think it's great. I think it's helpful. And I like it. So let's continue on. Let's take a look at the judge's delight with the panel of jurors today. Where did that go? I just pulled that up. I have too many tabs open. Oh, there it is. I pulled it up in the wrong window and I left it playing with no volumes because I didn't pause it. Oh, Emily, how many tabs are open? Too many. I need to be more I'm not caffeinated enough. So let's just peek in on jury selection real quick and the judge's delight with the jurors, because I am also delighted, and we will zoom to that. And we'll just go to court real quick. Why not? I like this judge. You can tell when Emily likes a judge vis-a-vis they're not my favorite. It's just there's no hiding it. There really isn't. All right. You hear no sound because there is no sound. I'm going to zoom to the judge getting onto the bench. Because this is what I'm pretty sure I saw this morning. So here we go. We're just going to Florida real quick. It's not even a layover. It's just a quick stop.
Good morning, ladies and gentlemen. Okay.
Wait, that's yesterday. Emily, did you pull the wrong day? Hold on. That must have been yesterday. No, that's day 2. All right, let's see how they respond after that. Because he was like, nah, not good enough.
Let's try again. Good morning to all of our prospective jurors.
Good morning.
Thank you. I'm Stephen Everett, one of your circuit judges here in Leon
There we go.
County for the Felony Criminal Division.
That was the good morning. We can look at what the lawyers had to say real quick if you guys want to. Let me put up a poll real quick. And then we'll just check. We'll just check real quick. We've got a minute, and then we'll go to questions. We'll look at the conference with the lawyers. I wasn't going to because I try to keep our streams to like 1 or 2 topics, 1 case. Everything's going to be on. Oh, actually, I can grab it elsewhere and it won't be on mono. But it was, the sound's not great in the morning. So I'm going to put up a poll and see if you guys want to hear the conference, and then I will grab a different feed because I have a different feed that I can grab. So we can do Doctor Who 2 topics in 1 stream. I know we're 2 cases, but it's fine. I'll add it to the notes. It'll be fine. Miguelina, do you mind grabbing me the link from Law & Order TV? I don't know. I don't remember if I grabbed it or not. I can try to go grab it, but you're probably faster. So all of you, 94% of you are like, let's do it. The sound is terrible this morning, but we'll just do it. And then we'll do some Q&A and then we will roll tomorrow. For those of you that are like, ugh, I'm out on Adelson. Totally fair. Totally fair. We switch topics. But tomorrow I am going to wait and see if they're going to be doing opening statements. If it looks like they're going to be doing opening statements, I'm going to wait to stream in the afternoon when they're doing that. If it looks like they're doing jury selection, then we're not going to stream tomorrow and I'll stream on Friday. Either way, I have some Band Mom snack bar duties tomorrow. So either way, tomorrow's going to be a shorter day. Let's see. No, I got it. So I just need to go grab a link that I didn't grab for myself. But that's the plan for Thursday, because if we're going to get started on trial, I need a day. And I want to see how close we are to the bubble of doing opening statements. And I'll let you know that in the Law & Order app this afternoon. It depends on how many. If they get like another 50 jurors today, then we're probably going to see them go pretty quickly through seat and yeet. So I will be prepared for that. And then I'll keep you prepared on the app, which I guess I should say, if you are a new Law & Order, if you don't have the Law & Order app yet, if you like to install the Law & Order app during trial and yeet when we're not in trial, you are not going to hurt my feelings. The Law & Order app is meant so that you have the information you want when you want it. That is what it is for. So lawandordapp.com, free on iOS and Android. Grab it and it will keep you in the loop when I go live. I do not know exactly when opening statements will be. So if they're Thursday, I'm going to send you a Law & Order alert. I can't rely on YouTube to alert you because it will alert some of you and it will alert some of you tomorrow and it will alert some of you like 2 days from now. And then you're going to be like, I missed it. We built an app so that you don't have to feel that way. And we have stress tested it. Sheila in the chat asked, how long is her trial going to be? Probably about 2 weeks. They're giving the jury an estimate of 3, but I think it's probably going to be 2 weeks. But Donna's going to testify. Donna's going to testify. So there's that. Donna is going to testify, and that's going to be incredibly interesting. All right, let me go grab the morning session here real quick. The sound is not ideal, but we will just deal with it. So let's swoop one more time and we will look at what the lawyers had to say this morning. Oh, for those of you in the chat that are just hearing that Donna's going to testify, her defense attorneys put it on the record. I'm going to make sure that I have the audio gained up a little. Her attorneys put on the record that she intends to testify. Oh, the questions for me are, how off the rails is Catherine McBanawal's testimony going to be? Because when Catherine McBanawal testified in her own trial, it was, I don't know what these people are doing. And by the time it got to Charlie's trial, Catherine's like, let me tell you what. I wonder if she was still holding back. I wonder if this is going to be a little bit even more. Wendy's going to be called to testify. They brought Charlie back into state so he can be called to testify. I don't know if he will be, but we'll see. But we know Donna's going to testify. It's going to be wild. Judge stated opening statements will start Thursday afternoon. He said if they're done. So it's likely that they'll be done, but things can go off the rails. But it's likely that they will be done. So the judge is hoping to do it Thursday afternoon. I trust his timing better than mine. Let me see. Oh, this browser is fighting with me on increasing the volume. Hold on one second. That's my fault. Let me switch browsers real quick. And then I'll be able to boost the volume just a little. And that should help because this morning's volume is hot garbage. Hot garbage. I also did this. So at one point, the closed captions might double up and that will get fixed pretty quickly. But that was me. I was tired this morning when I did this. So, all right. Now let's go to court. Now let's go. We'll deal with the sound, but it shouldn't be in mono. So there's that, I suppose. Yay for us. The judge is going to sound nice and loud. The attorneys are going to be hard to hear. I know he's laughing. There's no sound yet. We're going to have double closed captions for a moment once this gets started. And when they turn on the microphones, which they haven't done yet, I can't control that, unfortunately. And I am not a good lip reader. There they go. I told you. This is the volume from this morning. I am not joking. I can't hear anything. Let me try to sound booster it just a little bit more because I literally can't hear anything. And the audio gets better, but man, it's bad this morning. All right.
Which one?
There we go. That was gained up. That sounds a little bit better. Something's better than nothing. There we go. All righty.
I don't need to address it this morning, Judge, but at some point when it's convenient, I do want some clarification on what the pre-trial ones.
Which one? There are quite a few.
I want some clarification on some of the pretrial motions. The judge is like, there's a bunch. Which one would you like? So, yeah, no, get back here. Screen. All right, let's try to gain that up just a little bit more. But I want some clarification is where we're at.
The name change.
I like that he's amused.
Yes. Concerning that, go ahead.
Okay. So, Mr. Zelman was kind enough to send me a transcript of what you said, but I still feel like I'm not entirely clear on what is admissible.
Why did that go full screen? Sorry, chat.
There are
It's being weird.
References to the children by the defendant as Adelson, even prior to the legal name change. Would that be admissible?
What is the purpose that it's being offered for?
As part of the motive to basically erase the father and make the kids first.
What is the response concerning those?
Your Honor, this is an issue for Wendy's, not Adelson. I don't see how that's.
That was me. The defense attorney for Donna said, no, the district attorney said, look, about the name change, about the kids' names being changed from Markel to Adelson. The defense attorney for Donna is saying, I don't know how this is a Donna problem. This is a Wendy problem. Wendy changed the name. This isn't on Donna. This doesn't come up with Donna.
Relevant as to Donna Adelson, unless they can prove up that Donna Adelson was involved in doing that.
Are there any communications, anything that would otherwise show a demonstration or a tie
Deep
or some sort
fried
of link or
potato.
tie between Donna Adelson and Wendy Adelson when it comes to changing the children's names?
Yes.
Are they connected?
Communications referencing the children as Adelson, from Donna Adelson to Wendy Adelson, prior to the legal change.
And again, you're saying this goes to the motive.
Yes.
Do you have a copy of the email or communication?
No, sir, but on our next break, I can have that available for you.
Please do. Are there any other matters concerning the children's name change or any arguments that you anticipate bringing up in your case in chief concerning those?
No, I mean, I think what's.
I'm just trying to
out
fix
currently
the
is legal name
cropping on this real quick.
to it. So if these items are in that are tied directly to Mrs. Adelson, I would think we need to revisit. For context, you need to know that's before they would change their name. So that would be the only other item on the table.
Very well. Please provide the communication that you believe demonstrates the link or the tie. From there, I will address the ruling as need be. Mr. Zellman, you have a copy of the transcript that you both referenced earlier before.
Yes, Your Honor, it's what I have provided to the court.
Yesterday or when? In
I
February.
can email that transcript.
Yesterday or in February. That's kind of funny.
You can send it to Lynn. I will review it during the lunch hour.
So that's
Any
really
other
it.
matters that we need to address for this morning?
The name change is the biggest deal for the court.
No, Your Honor.
Right, and looking back at the progress that we made yesterday morning and yesterday afternoon, as far as having
And this
a
is
group
scheduling, which I'm happy
venire
for.
pool for
Your Honor,
jury selection on Thursday.
Emily has objections to
I
venire.
believe we currently stand at 64.
I will continue to say venire is probably technically correct. I just hate the way that it sounds. That's all. I just hate the way that it sounds. I hate it.
My total that I wanted to get to originally was 100. However, I believe with both the morning session and the afternoon session, if we maintain the same progress, in all likelihood, we will hit that 100 or
There we go. That looks
possibly
better.
even more. Once we've done that, we will be ready to proceed into jury selection on Thursday morning. The rulings that remain outstanding as to the defense's motion to suppress, the defense's motion in limine, the parts that have not already been ruled on, and the matter that was raised yesterday as to certain calls that the state seeks to admit. Those matters I am still reviewing. However, each party will have rulings on those matters before the jury selection with the group begins, if there are any topics specifically that you desire to inquire into that are related to the rulings. As to those matters, does either party need to be heard further?
No, Your Honor.
No, Your Honor.
Right. We'll just await the jurors at this point once they're brought up. Similar process to yesterday. I will just confirm that there is no other person that needs to be excused for statutory reasons. And then we will resume with the individual voir dire of the prospective jurors. How many do we have, or at least are expected to report this morning?
I'm bringing up the final number, but she had 55 checked in.
Oh, right.
That is what she would call it.
So they had 55 checked in this
With
morning.
55 having checked in, some may be excused downstairs. We may have some additional excusals once again from the courtroom, and then we will proceed.
Yeah, it's just gone really orderly and normal.
What's that?
Shocking.
Okay.
The
If you need to
judges,
use the restroom or take a break of any sort.
I just
please
hate
do
how
so now
high
before we
the
get
bench
going.
is, because the judge looks like he's like floating over the bench. It doesn't give enough like headroom. The bench is too high, but the benches are not ergonomically great, and they're often built into the courtroom, and you don't really get much of a choice.
This is unrelated to all these wires that are set up in here, right?
I can't hear what they said at all about the tech that they are asking about, but the court's like unrelated to all these wires and shit.
I am concerned, as always, with justice, but not to be burned up in a courtroom. Joey, appropriately inform us all.
The judge is a big fan of justice. I'm concerned, as always, with justice, but I would like to not be burned up in a courtroom. Oh my God. The wires must just be absolutely everywhere. But the bench is so high. I'm rewinding it. We're just doing it again. Like 100% just doing it
This is
again.
unrelated to all these wires that are set up in here, right?
They don't sell anymore.
I am concerned, as always, with justice, but not to be burned up in a courtroom. Joey, appropriately inform us all.
That's funny. Good point, chat. All of you are like, nobody's getting over the bench. I mean, that's fair. I guess I am particularly sensitive because a lot of my my female judge friends in California are like, these benches, I don't know who built them. I don't know what dimensions they built them to, but they are just an ergonomic nightmare for a lot of the judges just because of the way that they are built in. And I'm like, look, I need my stand desk. I don't always get to stand, but at least I can adjust the height for all the different things I'm doing. I'm too much of I need to control my own environment at this point. I could never. Petty cakes, that's funny. Chat is 10-10 with the swiftness. Just 10 out of 10. 10 out of 10. But the judge is like, there's a lot of wires. They're just chatting. We're going to sit and just noodle. Doctor Who, did I try sitting on a bench in court when it wasn't in session? Only if my friends were the judicial officers there. It's not a position I ever aspired to. I do not have a judicial face. I have a what the fuck face. Because if I'm thinking what the fuck, you're going to see it on my face. Which is not helpful if you were a bench officer. Also, lots of paperwork and lots of like hurting cats and other people's schedules. I'm also not patient. So yeah. All right. Well, back to the seal of the great state of Florida, or the great seal of the state of Florida. They flip those words around, so it's going to get just stuck in my brain. And then they go on to jury selection, which we already saw the beginning of, and that's where we're at today. I will let you know in the Lawnerd app at the end of today how many jurors they have, because we might get to opening statements tomorrow afternoon. I'm going to be prepared if we do. And if we get to opening statements tomorrow afternoon, then Lawnerds, we're in trial. We're in trial, which means I have work I need to do this afternoon. Team Baker has work we need to do this afternoon, but we might start trial tomorrow. So, all right, we might start trial tomorrow. Who knows? If we started on Friday, we started on Friday. If we start tomorrow afternoon, we start tomorrow afternoon. So, Diana loves the Crash Daddy said they have 55 checked in. I want to know, yes, they do. In the morning, they're going to have more in the afternoon. I want to know how many haven't been yeeted. Like, how many did they save? So that's what we're doing tomorrow. So Lawnerds, get the Lawnerd app. Let's go real quick to some questions, and then we will get on with our afternoon. And I will keep reminding myself to do laundry because it is on my list. And then tomorrow, I have some band mom duties. I'll tell you a quick story about that. RK, this is a 10 out of 10. RK said, I don't have a judicial face. I do have a judgy face. Me. And I can't even help it. And then I will see people look at me and just be like, and I'm like, my face is facing. It's better now. But I have a band bomb story. Angela, I see your question. Can we discuss Denver? I'm waiting to see if there's a statement from Boston PD. So if I see that, we will talk about it. I've seen reports. I'm waiting to see a few more reports. So, Emily, are you washing money? No. I have the joy of having my son's Cavalier performance show costume at my house, and it needs to be washed more. I've gotten the smell out of almost everything, but we're not done yet with the DCI smell. So we're not done yet. One of the things that band parents get to do, anyone who's been a band parent or a band member, this is not unique for band, but it is in fact a part of band. Other activities also require volunteer time. Band is not inexpensive. It's like having a kid in ice hockey. Band is not inexpensive. So part of what we do with band is volunteer work. I don't mind doing volunteer work. I enjoy it, especially when I can. One of the things we do for my kids' high school band is we work at the county fair. Look, this year the county fair rolled out a new feature, which was like a bite night, which I was likening to Taste of LA with Judge Abby. And I was like, they have like a Taste of LA, but like county fair version, where a bunch of the different food vendors were offering like sampling sizes of food. And so you could get like a ticket to go around and do sampling. So instead of getting like 7 or 12 deep fried Oreos, you could go get like 2 deep fried Oreos. And so you could do fair food sampling. And I was like, this is the greatest idea ever. I love this so much. I can't wait to go back to the county fair next year for bite night. This was the best idea ever. The county fair also falls on the first week of school in my county, which is a whole nother thing. And it's also always hot AF. And it's an actual county fair with like FFA competitions and all the rest of it. But I love the county fair. It's a lot of fun, but we work the county fair. One Doctor Who said, what's wrong with 12 deep fried Oreos? There is nothing wrong with them except I can't do 12 at one go. And if they get like soggy, then I won't eat them. I would rather have like sets of a few throughout the night. Goldilocks. It's like, ooh, now they're too mushy. Ooh, now they're too hot. Ooh, now they're too cold. Sensory issues. So I love the idea of like the bite night, so you could kind of do all the things. But one of the things we do is work the ticket booths. I worked as a cashier in college. I worked a whole bunch of different jobs outside of like lifeguarding and stuff. But I was working the ticket booth at the county fair as part of our band parent volunteer stuff. And a woman came up to my booth. Occasionally law nerds will be like, wait, holy shit, that's you. What are you doing in the ticket booth at the county fair? Band mom. Which is always fun when I scare the shit out of the law nerds. They're like, what are you doing here? I'm like, I know. There was a very lovely law nerd that ran into Chris and I when we were traveling. Emily, your story has a side story. Yes. Follow with me. We'll be back. Ran into Chris and I when we were going from the Houston DCI show to San Antonio, and was like, and I'm like, I know. He's like, but I'm like, what am I doing at a Buc-ee's in the fucking middle of Texas? It's like, exactly that. What are you doing in a Buc-ee's in the middle of Texas? It's like, well, we're driving from Houston to San Antonio, and this is the Buc-ee's in the middle. And so we actually scared the crap out of a law nerd in a Buc-ee's in the middle of fucking Texas, but it's Buc-ee's in Texas. Of course, that's where we're going to stop. It was very fun. So hello. We had a lovely time seeing you. But occasionally I will like jump scare the law nerds by doing random mom things. So I'm working the ticket booth, and this lovely woman, not a law nerd, comes up to me at my ticket booth, and she goes, I just have to tell you something. And at this point, I'm like, what have the high school kids done? Because the high school kids, the band kids are also helping facilitate the line. It's also the first week of school. The seniors are also senioring. There's like girls flirting with the drum major. It's very high school. There was a Labubu that got beheaded. That's for members only. Well, it's a story for later. But I was sitting there. My first thought was, uh-oh. And then she's like, your ticket line is moving faster than all of these ticket lines. Chat. I have never been happier than sitting there going, yeah, the fuck it is. Yeah, it is. Because I am type A competitive like that. So if I am going to work a snack bar, a ticket booth, a whatever, I am going to be the most fucking competitive person you have ever seen. I'm going to be like, these tickets are moving. Also, everyone's standing in the sun. It's hot. I don't want to get bored. I am slowed down by the speed of the credit card processing machine at this point, but I'm like, we run this line. Like, let's go. So it was so funny that she was like, I was watching all these lines. Your line is the fastest. I'm like, yes, it is. She's like, we actually moved lines because of how quick your line was moving. I'm like, uh-huh. I am great at selling things. I can sell tickets. I can sell snack bar. I can work a cash register, but I worked some of the cash registers I worked in earlier jobs were such a shit show. The fact that these are also digital and all the tickets are even round numbers and everybody has tap to pay. It's 2 tickets. Great. Same price. Tap to pay. Here's your tickets. But fantastic. Nothing keeps me happier than keeping it moving. Love it so much. So I rocked my ticket line and I had the most fun doing it because you get to see everybody coming to the fair and you get to see all the kids that are so excited. And then the teens who are all dressing like straight out of the 90s. First of all, there was some iconic nail art. Second of all, there is the entire gamut of like the junior high school students in the little like booty short skirt situations. They're adorable, but they're literally everywhere and they are all cookie cutter. And then there's like the high school kids that are like 90s. And then you've got the high school kids that are like a little bit more preppy. It was fun to see all the different groups of kids. And then the kids that were like, Travis's mom. I'm like, Travis's mom. When's he coming back? Like a week. But the people watching with the kids was so fun. And then, because college hasn't started yet, then you get like the recent graduates and the alumni in their 20s to mid 20s with their roadie cups. I'm like, y'all, there are like 3 sheriffs right behind the ticketing booth. So just so you know, there are like 3 sheriffs right behind the ticketing booth. I understand that rolling up to the county fair with a roadie is the best idea in the world because you are walking into the world of fried food, people watching, and the rest of it. However, all of the sheriff's deputies are right behind us. So just, there's a trash can, be chill. Just be safe, have fun. Crazy Cat Green is like, what is a roadie? For my definition of roadie, it is typically some type of soda cup, refillable soda cup from, doesn't even matter where, the 7-Eleven or whatever it is. Pick a gas stop where you can get a fountain soda of drink. But fountain soda of drink normally has drink plus booze. So the roadie normally is, yes, a big gulp of some sort that is spiked. So you can kind of tell when people are rolling in with the roadie mixed big gulp. So whether it is a vodka soda, whether it is beers, whatever it is, it is a roadie of booze. And it's absolutely hilarious because you can tell and you're just like, adult beverages Go in a Sonic big gulp cup. Yeah, exactly. With the ice. And look, Sonic drinks are 10 out of 10. And it's like, no, officer, it's a dirty Dr. Pepper. Blame the Secret Lives of Mormon Wives. There's no booze in that. It's just it's a dirty Dr. Pepper. What? So it's just funny seeing it's the people watching at the ticket booth of everybody coming into the county fair is 10 out of 10, just 10 out of 10. Also crushed the line. So had the most fun. And on that, there was a substantial need for snack bar on Thursday. So Thursday afternoon, I will be snack barring because I can. And I fucking rock a cash register at snack bar. And it's a lot of fun. So that's what I'll be doing on Thursday. But we'll have trial. So we'll get it done with trial and then we'll go from there. So it was a lot of fun snack barring. We're going to answer some questions, but yes, band parent involves volunteer time in a different level of volunteer time, but I dig it. So, Ashley Bound said, got caught with my roadie in college, big ticket. Oh yeah. Getting caught with the roadie is a problem. And look, if it was teens rolling in with the roadie, it would be a different vibe. But when you're like a sophomore in college, look, man, don't drive. I'm not giving you a hard time. Don't cause problems at the fair. Also, I don't know how you do it. Everything at the fair is going to make you puke. If you're getting on any of those rides, you're just going to vomit. But if you're rolling around with a spiked soda to get some deep fried Oreos, like, I'm not going to judge. Just don't drive. So anyway, some people are just rolling up on their golf carts and tractors and the rest of it. So I don't know. But if they're going on the rides, vomit. Just 10 out of 10. But the county fair is definitely the mingling ground for the like junior high and high school kids. And then there's for those of you that were asking about the FFA, the Future Farmers of America competitions, they do stock shows of goats and pigs and I don't think they have horses at ours. I think they had steer. And they had showing for all different kinds of chickens. I didn't know that fancy feet chickens were a thing that existed, but they had fancy feet chickens. They're very fun. They have little like feathers on their feetsies. It's adorable. And then they do livestock auctions as well. It's 100% a county fair. Helena asked if they had sheep. I don't remember if they had sheep. I think our fair had steer, but I don't remember. This year I didn't even get out of the ticket booth. So we'll see. But they have all the animal shows and then the auctions at the end. So it's very fun. It is a proper county fair. So let us continue. What did Dr. B think of the Charlie Adelson of it all? Well, we rolled the FAQ, didn't we? I think we did. Here's the thing. Dr. B and his cell phone are an ongoing conversation, but I was like, Dr. B, we really wanted to talk to you about Charlie Adelson and referring to himself as an oral surgeon when he may be a periodontist. But I'm not even sure if he's a periodontist or just calling himself a periodontist. I've got questions. But he's calling himself an oral surgeon. And Dr. B's like, periodontists can also be oral surgeons, but not if they aren't also an MD. That if they're just a DDS, they're not generally going to be like an oral surgeon because that's a really specific thing. But Dr. B's like, it just doesn't make a lot of sense because periodontists have like a huge ego. I mean, so do oral surgeons, but like, it doesn't make sense to me that a periodontist would even refer to himself as an oral surgeon. I'm like, could it be that he's not even a periodontist? And Dr. B's like, well, that would kind of make more sense. So yeah, Dr. B is very gracious. And I'm like, finish him. But Dr. B at the end of the day will just be like, I mean, he's not a maxillofacial prosthodontist, so. Would Dr. Charlie be called Dr. Charlie? Probably not anymore. I imagine the conviction for murder has negated his license. So it's confusing to me that a periodontist would ever consider themselves an oral surgeon. I just wonder, and I'm going to look into this more before trial starts because now I'm deeply curious. I just wonder if Charlie Adelson was a general dentist that was doing some perio work and some implants without being a periodontist that went through a residency for perio, without being an oral surgeon that went through, med school and the rest of it. I just wonder. I've got a lot of questions about that dental practice. I really do, but yeah, I wouldn't still call him doctor, former doctor. It's like Proctor, former trooper, former doctor, and for Tom Girardi, former lawyer. So, former, just former. It's fair. Sweet Tooth Fairy said doctor is not tied to his license. It's his degree, so he could still use doctor. It's fair. But doctor's also kind of a respect. So I think I would probably be like non-practicing. Julie said, I think doctor was shade by Georgia. It's funny because occasionally when Dr. B needs a little shade, I will say yes, doctor, in the tone of like a yes, chef. And he's just like, okay. And I'm like, yes, doctor. We'll get right on that. So sometimes when I'm being snarky. So maybe Georgia was being snarky. We'll have to watch. We'll just have to watch. Because I'm curious. We're going to get to a few more questions. And then I'm going to get work done. We're procrastinating answering questions. Burley said, life advice, never settle with bullies. Burley, I agree with you in the general principles of life. The only reason I would diverge when we are dealing with the TikToker is because at some point, the cost benefit analysis of money has to come into play. And it's how much money do you sink in legal fees versus what you're going to get out of it? Because at this point, the court has already said to the university professor, you were defamed. And I don't know if anything else is going to help. So we'll see. Laura M said, on delay, sorry if it's been answered. You don't need to apologize for questions. Questions are we love questions. We have questions. Will the TikToker have to testify? I mean, not have to. But what other witnesses will she call? I don't know if the TikTok, here's the bitch of the thing. I kind of love it. I don't know if the TikToker's testimony would be relevant. Hear me out. The issue in the TikTok, like workshop this with me, you guys. The issue in the TikTok psychic case is just damages. The issue of defamation has already been decided. The TikToker can't relitigate defamation. It's been decided. The only question before the jury is damages. So if the TikToker were to testify, I guess it would only be relevant to punitive damages, but because there's defamation, the elements have already been proven. So I don't know what the TikToker could say that would go to damages. It would be questions. Like the professor would have to testify and be cross-examined by the TikToker, which nightmare. But if the TikToker wanted to testify, A, she opens herself up to cross-examination by a lawyer. And B, I don't know what information she would have that would negate the damages by the professor that wouldn't be part of cross-examination because she doesn't know what the professor suffered. She doesn't know what the professor's, potential medical bills are or things like that, what the actual damages are. So I wonder if the attorney will try to limit her testimony because it would only be on the issue of damages. And as to punitive damages, I would need to look at the jury instructions, but it would be pretty constrained, but it would open her up to cross-examination. And on cross-examination, she's opened up to Wendy Olson, who's a former federal prosecutor, asking her questions about things that are going to go to the punitive damages and why essentially the TikToker, this will be the argument of the plaintiff, is just a menace who went on the internet and said, that woman, I'm going to make TikToks about that person because I saw it on a website. So that's not going to go well. It would be really interesting if the professor subpoenaed the TikToker and called her to testify. That would be wild. So we'll see. But I think there's going to be some constraints there because the TikToker can't just relitigate. KD asked question, how does jury selection work for this? Do they have to have no knowledge of Kohberger? No, they don't have to have no knowledge of Kohberger. It would just be whether they'd made up their mind with regard to the issue of damages in this case. Because even if they had made up their mind on defamation or like, oh yeah, I heard about that. I heard about the defamation. It's already been answered. They don't find liability. They're just answering questions on damages. So it's just really reasonableness. Hey, does this amount of money sound reasonable? That's it. And so I don't know if you're going to find jurors that had made up their mind on that. I haven't made up my mind on that. I don't love this case, but I don't know. Tanya said, applied for a manager job in the prosecution office. Good luck. Good luck. Good luck. It's, dude, hurting lawyers is like hurting cats. Erica kind of hit on that and said, I'm an exhausted paralegal. Yeah. Hurting lawyers is like hurting cats. Team Baker will tell you the amount of times Chris is like, but girl, I need you to do this today. No, but you have to do it today. A lot. Rachel said, EDB, have you tried Hank Green's new Focus Friend app for ADHD? I love it. I haven't tried it. Is it going to cut into the time playing Midas Merge and Pokemon Sleep? I will take a look at it. I hadn't heard, but I will take a look at that. Alley-oop, happy 2 years anniversary. Good to see you. All right, we just did the update on Dr. B. Tina said, so can we say talk to my manager, EDB? As for your excuse for jury duty, I need to work on that because look, if podcasts can give work excuses, which apparently they can, CEG Travis Kelsey, then we can too. Nana Banana, thank you for the gift of memberships. It's fantastic. Desi TP said, as a manager, I tell my employees, send them my way, which is a good manager. It's like, not, this is what I'm here for. Send them my way. You shouldn't have to deal with this shit. I got you, which is great. Fantastic. Michelle L said, I feel like maybe the prosecutor could have given the family a heads up about this so they could have gotten ahead of it with the law enforcement agencies. I don't disagree. I don't know if the departments are telling the prosecutor what they're doing because the public records requests are all facilitated by the agency. The prosecutor's office isn't necessarily engaged in it. I know the prosecution was aware that Moscow PD was releasing things, but like Moscow PD released things, but then the city of Moscow released things, and then Idaho State Police released things, Pullman PD released things. I don't know if all of that is being coordinated or if the public records requests are just operating separately with the agencies. But it seems that now the prosecutor is aware that this is a problem and should probably be asking their contacts about what's happening. And I wonder if it'll end up in front of Judge H. But some of those PRA requests are outside of the prosecutor's control because the agencies have to respond to the public. B-Rux, thank you for the gifted memberships. Liz Rose, good to see you. Happy 6 months to all the law nerds. Ashley Farmer, I hope that we answered this question with regard to Kohberger. I thought everything was sealed. The court records are, but these things aren't court records. And that's what makes it so difficult is that they are public records requests from each agency. And that's where the process got a little bit jumbled. The Cozy Treehouse said EDB Air Wings pin? Question mark. It's a great idea. Team Baker, I can disclose. Team Baker, cover your ears. We have talked about it a lot. Jojo said EDB petition for Law Nerd Jury notebook merch. We have talked about notebooks a lot recently. We have some new things coming. We have some new things coming. So don't worry. We will look. If I was inspired by anything in the podcast with the Kelsey brothers and Taylor Swift, it was the very, very good description of Easter eggs from Taylor Swift. I'm inspired. I'm inspired by the Easter eggs. So we're working on it. But there will be Easter eggs. Do not worry, there will be Easter eggs. Ned asked, why would the media want the photos? Ned, I have never worked in media in that way. I mean, I do my own thing. As a DA, I was always on the other side of like, no, talk to media relations. I did not foster relationships with members of the media as a DA. My answer was literally always no, talk to media relations. And then if I needed to provide statements from victims' families or anything to media relations, I provided that to them and let them handle it. It was one of those things that was just not something that I had a lot of time in my job for. And we had a media relations department or individuals to handle that. So I just did that. So I don't know. I think a lot of media agencies want to be able to say XYZ obtained exclusively and reviewed by us so they can have some type of a scoop to say, we obtained this, we reviewed it, we have the story for you. I think that most media agencies, when they run things through legal and through their own bosses, wouldn't publish those, but that's not true with everybody. So we will see. So I don't know. There's a lot of ways in law I can like see what both sides are going to argue, and I can be like, oh, they're going to argue this, they're going to argue this, these rights are here. I can both sides, most legal things pretty easily. It's really hard for me with media because I don't know. Because it's stuff I wouldn't ask for, and it's hard for me to put myself in the shoes of just continuing to push for more. But again, not a journalist. And so it's hard for me to wrap my brain around it. I did an interview. It feels like it's been quite a while now. I did an interview with Mandy Matney, talking a lot about media. And I would go look at that interview and how she describes what working in traditional media was like for her before she left, where her bosses were tracking an article that she wrote and how far down the page somebody read. If her headlines were driving people to go beyond the paywall, and how much her job was tied into keeping eyeballs on the page and making people read further down the page. So when you start to look at the way she is describing working inside of media, you can start to understand we need to have something that nobody else has. I appreciate the courts in Idaho being like, that doesn't exist for us. Everything's on Zoom. Nobody has anything nobody else has. There's everything. If we're giving it to anyone, we're giving it to everyone. The problem is then there's no checks and balances with what ends up on the internet, and that's where this lawsuit is. So I get it, but it's also hard. I also feel like what we've built here as law nerds is different, and we just get to do our own thing, and we don't have to rely on, I don't know, hyper sensationalized information. We get to go the other way because that's what feels best to all of us. And I love that. And I love that you guys are here for us. Member for 32 months, Sam said, what if the TikToker just stops responding now? I imagine a court order and then fines, like day by day by day fines. And then what happens? Oh, we'll see. Lupe Crochet says, poor professor, this is how I felt since the beginning of this case. There was no good resolution for the professor. The win at summary judgment was the best possible outcome, but it's still expensive and burdensome. I think at one point the professor had a GoFundMe. I hope that the lawyers are being mindful of trying to keep everything to what's absolutely necessary. But it's hard when the other party isn't paying lawyers and is just like, I'll just file this shit that you have to respond to. It's a conundrum, and it frustrates me for the professor. Catfink UK, congratulations. Just been offered a new job after being laid off. Congratulations. I hope it is awesome and that you love it. Look, there are ups and downs to everything, but finding a job that you love helps. Because again, I don't mind working. I just want to do it in my own, back to Goldilocks. I just want to do it in my own way with my own temperature, with like at least 4 different types of drinks and nobody touching my pens. It was so funny. We were doing back to school stuff with Griffin, and one of his teachers was like, we have just gotten to a great place where Griffin and his teachers and his classmates, everybody understands that Griffin really is not amenable to somebody just being like, I'll just borrow this from you real quick. He's like, do not touch my stuff. Like, do not touch my stuff. Just don't touch my stuff. You didn't ask me, don't touch my stuff. And junior high is hard, but it looks like everybody's in a respectful place with just don't touch my stuff. Yes, don't touch my stuff. With that, law nerds, there is stuff that you can touch. First of all, the like and subscribe things here on the YouTube. Members, remind me to tell you again, because I don't think we did a full story about the pen fights in the DA's office when I was a newer DA. I got delightfully petty. I thought it was hilarious. You can let me know, but we'll talk about that on Members Only Live this month. I will need to make a note so I don't forget. So touch the subscribe button, like the video, go to your app store, and you can get the app. Like, the app is my stuff that everybody can touch. All of you can, on your own phones, in your own way, lawnerdapp.com, because it looks like we might have opening statements in the Adelson case tomorrow, which means I have some work to do today. You guys you know what trial's like. Is there anyone in the chat that hasn't done a full trial with EDB yet and the law nerds? Just pop a 1 in the chat. Pop a 1 in the chat if you haven't done a full trial with EDB and the law nerds. Because if you have not done one yet, look. Get some laundry done. Get hydrated. Go get some snacks. Get ready. However, there will be a weekend, but it looks like we might do opening statements Thursday afternoon based on how many jurors they had at the end of the day yesterday. So if it goes on schedule Thursday afternoon, if not, we'll be in trial Friday. So get yourself ready. If you have emails you need to answer that you've been putting off, just do it right now. You know how before you have something big to do, all of a sudden you need to do all the other things? Like, oh, I'm traveling. Now I need to go reorganize my cords so I can find the one that I like when I travel. Do that today. Take the time to do that today. Get things in order so you have some days to enjoy being in trial. Because if Wendy Adelson's one of the first witnesses, this trial is going to hit the ground running, and you want to be ready when it does. With that, law nerds, we live here now. We're moving to Florida. So before we leave, we're gonna zoom to Tallahassee. Can't wait. We'll see you all there. It's probably humid, so just get ready. Get ready for the humidity. Get ready to stay hydrated, and we're gonna get going. So to trial, law nerds, to trial. It's almost time.
Bring the jury.
It feels like we just got out of trial, but then again, I also miss it. So we're ready to go. Hopefully sound will be better, and we're all ready to go. I will see y'all, Thursday afternoon or Friday. Stay tuned in the app. We're going to see if I can do the EDB air and then the outro and make it all work smoothies. We're going to see. We're going to see how that goes. Wish me luck. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.